right, I'm gonna hop in. Good morning, everyone. It's Friday, February 7th, 2025. We have 13 bills on the docket. We're going to start off with Senator Henson with Senate Bill 507. We're then going to move on to 509 and then 512. Then we'll loop back up to Senator Augustine. Senator Henson, you're up.
May I bring up my panel as well? Senate Bill 509.
Good.
Thank you. I believe I have Paul Newstead here from the Maryland Psychiatric Society. Okay, I'll get started. Thank you, Mr. Chairman. For the record, Shanika Henson, Senator for District 30, Annapolis and Anne Arundel County, here in support of Senate Bill 509, prohibited possession of firearms assisted outpatient treatment respondents. This committee and other committees in this body has done a lot of work to make sure that people have access to mental health treatment. One of those things that the committee has done is they stood up a system of assisted outpatient treatment so that folks who had critical and severe mental health illnesses were able to get treatment. They are under a court order for this treatment, so it is a structured treatment, and there are a number of compliance requirements while they're under that court ordered structured treatment. One of the loopholes that we discovered is that we had not prevented people who are seeking that treatment from possessing a firearm. It is a critical part of the treatment. One, for suicide prevention, it's very necessary. Also for public safety, making sure that persons who are undergoing that treatment don't have access to a firearm is critically important. So this bill would just seek to continue that work and close that loophole to make sure that persons who were in assisted outpatient treatment did not have access to their firearms during that treatment, but were able to engage their treatment in a way that would be successful and productive. And with that, I would ask for a favorable report on Senate Bill 509.
Excellent. Thank you very much. Do you want to bring your panel up? And
I called out for Mr. Newstead. I did not hear him, so I don't believe he's here. I apologize, Mr. Chair.
Okay. And is Linda?
Oh, no, that's for staff.
Oh, sorry, that's right. Okay. That's right. All right, so then for questions for the sponsor of the bill? Senator Fulton.
Thank you, Mr. Chair. Good morning, Senator.
Good morning.
Thank you for bringing the bill. I just wanted to ask, I didn't have a chance, I'm sorry, I'm trying to look through it quickly, but I see you're talking, I'm going to assume, but I need you to clarify for me. Under the general health article 10-6A-08, is that like, what type of treatment is that?
So it's for assistant outpatient treatment is for persons that have serious and persistent mental illness. The process is that a petitioner would then go to the courthouse. They would say this person has a severe and persistent mental illness and they're not undergoing treatment. As a result, they're a danger to themselves and they're a danger to the public. The court would then make an evaluation based on the evidence presented if this person needed to be under an order to seek that sort of treatment. Now, it's not an order where they would be confined to a facility. They do still have their liberty, but they're participating in a structured assisted outpatient treatment plan. The coordinator would come together, develop a plan, and then the court monitors that plan for compliance.
Okay, well, I guess my confusion is, didn't this body already pass the red flag law, which would encompass this? I'm sorry?
You did and you didn't. You do have those extreme risk protective orders, which are the law of the land.
Aren't we on?
But this is not, in order to be qualified for an extreme risk protective order, you have that qualifying list of things that you would have to have done, the acts you've committed.
Okay.
Under the assistant outpatient treatment program, you don't have to have harmed someone. You just have to have that potential to be a danger to yourself and to others.
But you don't have to have that in an ERPO either. You just have to have a petitioner that goes and already makes a request in front of a judge of why you're not sound or of good mind to be able to, and that they're in fear.
These are two very different things. This one is, the purpose of it is a treatment plan, is what results as the final order from this.
All right.
Under an ERPO, I understand what you're saying. You do have the right to then deprive that person of their firearms if they have them legally.
Okay.
But this is different because the purpose is treatment. We don't want to have two orders by the court. We want to make sure for judicial economy that under this one, they do have the right to have that relief as well.
Okay, thank you.
Thank you, Senator.
Asked the same sort of question Senator Fulton did, but so under the red flag bill, there's a rather extensive procedure set up for bringing someone into court and actually removing the firearms from their possession. Under this bill, what sort of how do you effectuate the requirement that the person no longer possess firearms during the period of the treatment?
So the broader policy bill was passed last year, and the broader policy bill, that's a process where the petitioner comes in. This is just tacking on a form of relief to that broader bill. But under the bill, it would be similar to what happens under the ERPO. You would have that order. You would have the same enforcement mechanism where a sheriff could enforce that order where the person had to turn over those firearms. So it would be a parallel process.
Okay, thank you for that.
Thank you.
So when I went looking into this, and it kind of was at the same, again, I mean, I hear what you're saying, that it's different, but it still seems very much the same to what the ERPOs are. But when we're talking about a bill that, you know, I'm looking at, this is from the Office of the Public Defender, that an assisted outpatient treatment from possessing a firearm, rifle, or shotgun would require the courts to report sensitive information regarding these individuals to the NCIC system. And while well-intended, this bill will do more harm than good. I don't, there's no evidence like they're saying. I'm reading this and I'm agreeing, one of probably the few times, with the PD's office, but there's no evidence that suggests categorically that those type of assisted outpatient treatments, because it doesn't really narrowly define it according, that it would prohibit all individuals subject to an AOT. And they suggest that whereas only 3 to 5% of the violent acts can be attributed to individuals living with serious mental illness. Can you speak to that part of that?
I can. I think the major impetus for the bill is suicide prevention. So in order to have a AOT treatment plan instituted by the court, the person has to have a serious and persistent mental illness. So we're talking about a very narrow subset of people who would even be eligible to be under this sort of court order. And if you think about just practically people who are in that condition who need the supervision and support of the court, also having access to the firearms, I think it's not a big leap to then get to this being an issue of suicide prevention and also a matter that's for public safety as well while they're under the treatment plan.
Would this bill not put those same people at risk by not coming out and seeking treatment then because of their fear of having their firearms taken away?
So I don't want to relitigate the original AOT work because there was so much intentionality behind that work, but under that statute, a petitioner would come forward and petition the court for this sort of order to happen. It's kind of premised on the person who has the severe and persistent mental illness, perhaps not being at the sort of state where they understood and recognized the need for care.
And that's kind of my point. I'm glad to hear you say that, because under my understanding was that was the very intent of the ERPO law, is those people that are suffering from that their family, a doctor, law enforcement have a severe concern for their safety and well-being for themselves or others, that they can petition the court and do that. This just seems duplicative in its effort, but also just kind of trying to broaden that even more against anyone that goes for assisted outpatient treatment. And that is, I think that's a very slippery slope. So
I would push back on the premise that this would impact anyone that seeks assisted outpatient treatment. This is a very narrow classification where a petitioner comes to the court and receives an order that someone with a serious and persistent mental illness needs the support of the court for assisted outpatient treatment. So it's not that anyone who seeks psychiatric care or mental health care would then be subject to having firearms taken away. It is a very narrow group.
And I appreciate that, Senator. I'm just reading back verbatim what the Office of the Public Defender says, which is this bill would categorically prohibit all individuals from subject to assisted outpatient treatment from possessing a firearm, rifle, or shotgun. And then it also says there is no evidence suggesting that all individuals with this in an assisted outpatient treatment are violent or have violent behaviors.
With all respect, I think the public defender, pardon me, please finish.
I said, and these behaviors, this is a restriction of their constitutional right and freedom. So we're getting into someone that is not necessarily even, proven to be the violent or have violent behaviors requiring these restrictions of their constitutional rights and freedoms. I think we're really getting into another opportunity, another worrisome area where, the intent versus what the outcome is going to be dramatically different. So
I think if we limit the scope to that reasoning, and with all respect to the public defender, their focus is based on people who are in a criminal legal system, people who are defendants, focused on those criminal rights, and a person who may be a threat to the public. The majority of this bill and the majority of the good that will come from this bill is suicide prevention. So I think the public defender is speaking about, is this person a threat to the public, and their focus is limited to that. I'd ask you to just focus your consideration on the broader scale, which is persons having access to firearms, knowing how prevalent they are in completed and successful suicides. We want to give them the opportunity to engage treatment, to get a treatment plan before those firearms are there, so hopefully we can save a life.
I appreciate that. And one last question, Mr. Chair, it'll be brief. The Disability Rights of Maryland wrote in an opposition letter because they have concerns that placing individuals ordered to comply with assisted outpatient treatment. And some of that goes by which part of the state you're in and the judiciary that sits in those benches and how they view things. So that would be one thing, but plainly in the NCIC or NICS, plainly contravenes federal law, which explicitly limits the use of NICS to individuals who have involuntarily committed to an inpatient psychiatric facility. Using NICS for purposes beyond that is intended, it violates federal law and places individuals subject to assisted outpatient treatment at an increased risk of harm such as decriminalization or discrimination, criminalization, and economic disadvantages. So what I'm hearing them say is that because of that, these people with disabilities, it's now violating their rights.
I believe the letter from the Disability Rights Group is drawing the nexus between persons with disabilities and their overrepresentation in the criminal justice system. Again, I would ask you to also focus on the prevention for suicide. That's a part of the bill. I think that when you narrow it to just what's the impact for persons who might be a threat to the public, you really do lose the spirit of the bill. I'd also ask you to take a look at the testimony from Johns Hopkins University that was in favor of the bill, and I think they did a fantastic job at laying out the risks that are associated with people having firearms during that state and the real impact for suicide prevention that the bill has.
Okay, thank you.
Thank you.
All right, further questions from the committee? All right, thank you very much, Senator. Thank you.
Thank you.
All right, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. And is Courtney Bergen here? Come on up. And then is Ms. Dartigue here? Or anyone else from the public defenders?
Good morning. I actually spoke with Courtney, and I'll go. Excuse me. I'll go first. So, good morning, everybody. Crystal Williams with the Office of the Public Defender. Good to see some familiar faces, and good to be back here in this committee. And I just want to thank so far the individuals who have asked questions and have provided testimony on this bill. We would like the opportunity to speak with Senator Henson further about this bill because we do certainly have concerns, and so we are here to express just generally our opposition to this bill, given the concerns outlined in our written testimony, and I'll just go over them briefly. But this bill would, and in fact, categorically prohibit all individuals, as outlined in the bill, who would be subject to the assisted outpatient treatment program from possessing a firearm, rifle, shotgun, and would further require these individuals to have to report sensitive information regarding their mental health condition to the National Instant Criminal Background Check System. As we noted, we do feel that this bill is well intended. Obviously, there are many efforts that need to be taken to curb gun violence and, as Senator Henson said, absolutely to also curb suicide. However, as we noted, there is simply no evidence to suggest that individuals who are subject to the AOT program fall within that category and are actually profiled as individuals who meet the criteria of being suicidal even, or a risk of dangerousness or risk of being violent. Those are factors that are determined by the court. Those are factors that are determined by other conditions and evaluations and assessments. But the AOT program was specifically designed, and it's my understanding I was not here last year, but looking at the testimony from last year and speaking to attorneys and individuals and advocates who worked on this bill, this was one of the fears that would have come out of the AOT bill, the statute that's to go in effect this year. It hasn't even gone into effect yet, but this is one of the things that was warned about, that was concerned, that additional rights would be prohibited and trampled on for individuals who are experiencing mental health conditions. And so we do oppose this bill. We do think that there certainly are other efforts to address suicide prevention, as well as individuals who have a risk of dangerousness. And so I'm happy to answer any questions, but I also defer to Courtney as well as an expert. Thank you.
Just wanted to capture the moment in time where we saw a public defender standing at the podium and Senator Folden nodding in agreement. Just want to take note of that. Go Birds.
Good morning. My name is Courtney Bergen. I'm Equal Justice Works Fellow and attorney at Disability Rights Maryland. I'm also someone living with serious and persistent mental illness. DRM strongly opposes SB 509, primarily because, as others have said, AOT does not require a dangerousness finding. So putting people on the National Instant Criminal Background Check System can have serious collateral consequences. And so while we would not normally be up here, advocating for gun rights, this is for us more about the collateral consequences. And this is something I can speak to personally. I am in this system, and the harm it has caused me is indescribable. And I'm in this system as a result of another Maryland law where someone gets put in there automatically when they're in the hospital for longer than 30 days. I was there voluntarily in a hospital that had a minimum stay of 30 days. So when we pass these laws that have very broad implications without a requirement of a dangerousness finding, the consequences are huge for our clients. It puts people at increased risk of criminalization. We have clients who are in jail right now whose only crime is possessing a firearm, which they are not permitted to possess because of being in a hospital previously. And then we have folks who can't get professional licenses because they appear in NICS. And again, I'm one of those people, and when I was getting a bar license, had to disclose my whole background and actually had to get my public defender to write a character reference for me. It was humiliating, it was arduous, and it was unnecessary. I have never broken a law, never been arrested, never been violent towards others, and never used a gun towards myself either. So we want to make it clear that people who are, found needing to need AOT are not being found to be suicidal or a harm to others. They're just being found to have serious and persistent mental illness and to be non-compliant with some sort of treatment. That can be a very broad category and is non-specific about any specific diagnosis. So we would just ask you to oppose this bill and perhaps think of more narrowly tailored solutions that are focused on harm to others and self. Thank you.
Excellent. Thank you very much for your testimony. We have a couple questions from the committee. So we'll start with Senator Fulton, then I see Senator Henson.
Thank you, Mr. Chair. You mind standing up?
Oh, sorry.
No worries. So this is one of the unintended consequences that I clearly, even with my limited background, right, didn't pick up on. And I found that your story very moving because so what you said, I just want to be sure I have this factually correct, okay, ma'am? So what you're saying is you were someone that recognized whether it was anxiety, whether it was whatever, because you went and sought out on your own assisted outpatient treatment to an extent, or that you were in the hospital, I'm sorry, more than 30 days, and getting these treatment that you had to be entered into because of a law enacted here, that you had to be entered into the NICS system?
Yes, that's correct.
And so I guess what I'm asking is I kind of feel like that's a violation of HIPAA.
It certainly feels like it.
Because it's violated your personal, it adds more to your mental health concerns because you're trying to do what's right for your person, your own mental health. You're not a violent person. You're not a threat to anyone else. You haven't made any threats towards anyone else. That would be encompassed under the ERPO law. But if you wanted to go out and you found, like many veterans coming back from the military, they come back, they experience PTSD. They experience very distressing anxiety.
Right.
One of the things that actually helps a lot of veterans is they go out and they'll fish, or they'll go out and they'll just shoot targets, steal targets. And that just gives, oddly, it's a wonderful, just a calming feeling of control again, that they're actually able to do the mechanics and operations that they've been trained to do. So I have concerns, and I hear that, and I thank you for coming forward and sharing your story, because it's something I would have never thought about, that part and how it is connected and seemingly a violation of HIPAA. So I want to look into that further, and I thank you for coming out today.
Mr. Chair, my question is for our representative from the Public Defender's Office. If I heard your testimony correctly, you mentioned that there's no data to suggest that a person who's subject to assisted outpatient treatment was more likely to be at a suicide risk. If I may read just a portion of the testimony from Dr. Neustadt. I wish he could have been here today, but he did submit written testimony that says, individuals under AOT orders represent our most severely ill psychiatric population. These are not individuals receiving routine outpatient care for anxiety or depression. Rather, AOT candidates have demonstrated severe psychiatric illness leading to repeated hospitalizations or incidents of violence, along with documented non-adherence to voluntary treatment. Many experience profound psychosis, severe mood disorders, or other conditions that significantly impair their judgment and insight. While the common narrative paints these patients as dangerous to others, the fact is that they are at high risk of harming themselves, an outcome that this bill hopes to prevent. The research on suicide risk and firearm access is unequivocal. Every study examining this issue has found that access to firearms significantly increases suicide risk. Handgun owners have dramatically elevated suicide risk. Men who own handguns are 8 times more likely to die by firearm suicide compared to non-owners, while women handgun owners face a staggering 35 times higher risk, and that's quoted from the New England Journal of Medicine. Having had an opportunity to hear some data and digest that, is it still your contention that folks who are under an outpatient treatment order are not at a higher risk of suicide?
So my statement was in response to your earlier focus of the bill, of this particular bill. And so we did want to find out what the underlying premise was in terms of the impetus of providing this prohibition for the AOT statute and for individuals that are subject to participate in that program. And so hearing that that is the motivation behind this bill, that certainly is understanding in terms of the need to address suicide. And it's something that, has been wholly underfunded, wholly under-investigated and addressed and treated, something that impacts many people. And so it is very important that we do things that are going to carefully address that issue and look at what you mentioned in terms of access to firearms, rather than putting a statute in place that is going to potentially further criminalize individuals who may not actually fit into that category. And so while individuals who are subject to AOT treatment may have a risk of being suicidal, does not mean that every single respondent, which this bill speaks to every single respondent that would be subject to a court order, would have to comply with this particular bill. And so that encaptures other people, individuals such as Senator Folden mentioned, hunters, as Courtney mentioned, everyday people who experience mental health conditions. We're talking about veterans who have PTSD. We're talking about people across the board. But when you want to prohibit guns from people who have a risk of harming themselves, the solution is not to criminalize them. The solution is actually to look to ways to give them access to treatment, give them access to services. And so that would be the response that we would find to be most helpful and beneficial, because this particular bill simply provides a penalty, and it actually could prevent individuals from seeking out treatment. Individuals who actually seriously need it could be deterred because they don't want their rights to be taken away, they don't want their liberties to be taken away, and they don't consider themselves to be individuals who fall into the category of suicidal. And so if that is the focus, I think we need to narrow in terms of what the focus is and carefully figure out a solution to address individuals who may pose a harm to themselves. But to that, I would also say, we do actually have laws currently in place that can address individuals who are on that more severe end of needing supervision or care to prevent them from having a firearm. Maryland has plenty of statutes in place that would allow for that to take place and to restrict those individuals from having firearms.
You mentioned the word criminalize several times. If I'm understanding AOT correctly, the goal is to not criminalize. The goal is to have this civil process where a person has the nudge from the court to seek treatment so that perhaps they don't commit a crime, because we know that people with mental illnesses are overrepresented in our criminal justice system, partially because of such a lack of care. So if your goal is to not criminalize, then I think we're on the same page as it relates to AOT in general, and then as it relates to this very narrow provision that would alter that existing statute. You also said that it might dissuade people from seeking treatment. The AOT process is that someone comes in and petitions for treatment. So I just want to be clear that we're not talking about a process where someone's come and presented themselves, but we're talking about a process where the illness is so severe that a petitioner has had to come to the court to seek treatment, to help this person seek treatment. So I would only just want to clarify with regard to that portion of your statement.
If I could just respond to that point. So although they would be petitioned, they still have the opportunity to voluntarily get care. This is not court-mandated forced treatment. The AOT program still does provide for voluntary treatment. And so it is also important to make sure that this body is aware that these are individuals who still are in the community, deemed not to be at risk of harming themselves or others. That is the entire purpose of the AOT program. But it is also, as you mentioned, a nudge for them to get treatment, but a nudge for them to do it voluntarily at the onset. And so to entirely sweep everybody within that profile as then falling within the same category where there are standard limitations already in place for prohibitions on firearms, it could have damaging effects on those individuals who may want to voluntarily seek care or get that treatment and thinking that I'm going to have my rights taken away if I go forward with this.
I understand your testimony and I understand your objection. I think where we differ is if you have the opportunity to save a life and to prevent suicide, even if you have to apply that standard across the board, I'm of the opinion that you take that opportunity to save a life and prevent suicide. But I fully respect your opinion on wanting a more narrow approach, and I thank you for your testimony.
Thank you, Senator.
Thank you, Mr. Chair. One last thing. So in my now 30 years of law enforcement, I've seen a lot of unfortunate suicides, right? And what I will tell you is overwhelmingly, if we're going to do this for one facet and have this reported under the NICS system, for someone that's seeking voluntarily treatment to help themselves be whole again, why aren't we doing? Are we going to do this on pills? Are we going to do this on knives? Are we not going to allow them on the Bay Bridge? Are we going to tell them that they're not allowed to buy illicit drugs? I see way more people dying in those avenues of knives, overdosing by pills, or CDS than I do with firearms. And these are the people that need the help the most, and they're already fearful because there's always collateral damage, and that damage ripples out far and wide, and it affects them when they're on their journey to better mental completeness and a solid foundation when they go to apply for a job and it comes up in a background check that we're in the hospital or they're in the NICS system. That's completely unfair, and it creates a huge chilling effect to anybody that really might want to find those treatments. So would you agree with that?
So I would agree with that. I certainly do not want to undercut the fact that firearms are a real issue, and firearms contributing to suicidal deaths is certainly a real issue that needs to be addressed. I think the issue with this particular bill is that it is capturing a wide swath of individuals who may not actually fit into that category. But also, to your point, the focus should really be on
mental
treatment,
health. Correct,
and prevention of access. I mean, there are other ways to prevent access of firearms. Maryland still has a long ways of going in terms of safely storing firearms and making sure that there's not so many firearms even readily accessible.
Right.
And so I think the focus should be tailored in other areas to address them, as I mentioned in my written testimony, individually, but we cannot deny that there are certainly those ties, but there are ways to address it that doesn't then trample on the rights of individuals who should not have that.
I agree
taken away.
overwhelmingly treatment is far more the area that, important area that we need to be putting energy and funding into. Thank you.
Thank you.
Thanks. Further questions from the committee? All right, thank you both very much.
Thank you.
All right, with that, that'll end the hearing for Senate Bill 507. We'll now move on to, which one do you want to do next?
That was 509, Mr.
Oh, sorry, yep.
Can I do 507?
Yes, 507.
And may I bring up my panel?
Yes, please.
I have joining me Melissa Rosenberg, the Executive Director of the Autism Society of Maryland, and Melissa Scales Hamilton, who is a parent. I believe Ms. Scales Hamilton, we signed her up as Linda Bonner on the oral testimony, but she is going to stand in her place. Good morning, colleagues. I am, for the record, Senator Shanika Henson, District 30A, Annapolis and Anne Arundel County, here to present Senate Bill 507, Criminal Procedure Diagnosis of Developmental Disability of Intellectual Disability Evidence. What this bill does is it seeks to include in our statutes a consideration of a person's developmental or intellectual disability in our criminal legal process. I have here with me Ms. Rosenberg, the Director of Autism Society of Maryland, and I have Ms. Melissa Scales Hamilton. I'll let you know Ms. Scales Hamilton is very nervous to testify before our committee, and I told her that you all were lovely people, and she would have a lovely time here testifying, and I know that that will be true. What the bill does is it simply requires our court to take a diagnosis into consideration. There are a number of touch points in the criminal legal process where having the context of someone's diagnosis on the autism spectrum could inform our legal process and make the process more fair for them and also more fair for our criminal justice actors in the system. With that being said, I will turn it over to my panel.
Good morning. I'm Melissa Rosenberg. I'm the Executive Director of the Autism Society of Maryland. I'm here today on behalf of our organization, the Autism Society Baltimore Chesapeake and the Autism Society of America. That is our parent organization, and our two Maryland affiliates collectively serve over 20,000 Marylanders annually. SB 507 addresses a critical issue within our criminal justice system: the fair treatment of individuals with developmental or intellectual disabilities during legal proceedings. These individuals often face unique challenges and without proper consideration of their diagnosis may be denied a fair and just legal process. SB 507 addresses some substantial gaps. It would permit the introduction of evidence of autism or an IDD diagnosis in the criminal proceedings, ensuring these conditions are considered when making pretrial release decisions. It requires judges and district court commissioners to acknowledge a defendant's diagnosis, and it allows expert testimony on autism and its potential impact on the crime in question. A similar bill passed in Virginia. Our local and national staff are responding to a rising number of calls from families seeking help after their loved ones become entangled in the system. And we know that our folks are overrepresented in the criminal justice system, 7 times more likely to be victims of crime, 12 times more likely to become involved in the criminal justice system without intent, 5 times more likely to be incarcerated than the general public. Autistic individuals from marginalized communities are at even greater risk of being misunderstood, unfairly prosecuted, and subject to harsher penalties. We strongly support SB 507 as a critical step toward a more just and equitable legal system here in Maryland for individuals with developmental and intellectual disabilities, and we urge your support. Thank you, and I will turn it over to Ms. Scales Hamilton.
Good morning, and thank you for your time. For years, I have advocated for individuals with disabilities, ensuring that their lives in a community that will protect them. But one August, this cause became personal. I became mother of a child with an autism diagnosis, a child who is being caught up in the travesty of injustice that does not take into account his autism. Today, I am living my worst nightmare. My child is suffering because the criminal court system and the jail does not understand autism. It does not see the overwhelming weight of sensory overload, the terror of separation, or the devastation of isolation. Instead, it supports my child with punishment. The jail is not equipped to deal with my child's disability. Already, the conditions there have required that my child be placed on suicide watch twice. My child is suffering and is not receiving treatment. My son, my daughter, and my child's lawyer have all made efforts to deal with this the best way they can in the jail, and it simply is not equipped to handle it. And it is cruel to subject someone with such a disability to such conditions. Since my child was removed from my home, my world has been crumbling. I'm sorry. I experience internal tremors and earthquakes all the time and all day long as I am drowning in this valley of shadow and death. And when I hear my child's voice, their pain is unbearable. My plea for answers are going unanswered. The criminal procedures keep failing. And the basic rights of a person with a disability again and again. Despite my suffering, I continue to work helping individuals with autism find meaningful work. But as I look into their eyes and conduct my sessions with them, I see my own child, and the pain increases, finding myself to take several breaks from work, and I'm wondering who is showing up for my child. I will never, ever stop advocating for the adults and their families. I ask of you to stand with us and for this injustice to take action so that other families do not have to feel this agony. Autism cannot be cured. It cannot, but it can be supported, understood, and met with consideration of the diagnosis. By passing this bill, as it requires that the judge and the commissioners must consider any diagnosis for the defendant as a developmental disability and as intellectual disability, will make a pre-trial release determination. I ask of you to stand with me, stand with my child, stand with every child who has been punished for just being born differently. Please support SB 507. I thank you for your time today.
Ms. Hamilton is?
Yes.
So it takes a lot of courage to come down to Annapolis and testify, and it takes even more courage to share a personal story. So I just want to say thank you for taking your time to come down and testify and advocate on behalf of your son and many others. So I just want to say thank you for your time. Senator Sidnor.
Thank you. Actually, you may be able to answer. If not, I'm trying to understand. This evidence isn't currently prohibited from coming in. So, what are we trying to do with this?
So currently, there are two touch points where a person's diagnosis would be considered. That's the evaluation of competency and then evaluating criminal responsibility. Those are two very high bars where you're talking about, is a person able to be held responsible for a crime that they may have committed? What we want to do is infuse that standard at other points in the process. If you're making a pretrial release determination, we don't want the courts to be able to overlook that. We want them to take into consideration treatment that a person person may need, other sensitive needs that the person may have, whether it's sensory or other things that make a different placement for them more suitable considering their diagnosis. So what we're seeking to do is to make sure these things aren't overlooked at other points that don't rise to that level of criminal responsibility.
And that's not being done right now.
That's correct, Senator.
Thank you.
Thank you.
I get the same question, actually. In the law, is there some section of the law currently that says that a court is not permitted to consider this sort of expert testimony at any stage in the process?
No, what it would do is it would affirmatively open that door. So it's not that we're striking a provision of the code that says that you can't, it's that we're affirmatively opening that door and starting that conversation with the courts.
But I'm sure, why do we have to, if the rules of evidence currently permit this testimony to come in, and there's nothing in the law that says it can't come in, why is it necessary to affirmatively say it can come in? Because there's lots of evidence that can come in based on the rules of evidence. And we don't affirmatively say that one kind of evidence as opposed to another can come in. As long as the rules of evidence say it can come in, then the courts let it come in. So why in this case do we have to pass this bill?
I think you hit the nail on the head there. When you leave things to judicial discretion, you get inconsistent results. And sometimes a litigant may be able to have their evidence considered, and other litigants, for a variety of reasons, may not have those certain considerations made. So when you authorize this in the law and you start the conversation, I think you take the discretion in a way where the courts cannot overlook this, and that's what we're seeking to do.
But I'm looking at the bill, and it merely says that evidence is admissible. It doesn't say it must be admitted, and whether or not to admit any evidence is up to the judge's discretion based on the rules of evidence. So you're saying this bill would override the judge's discretion in every single case and require the judge to admit evidence that for whatever other reason the judge might not feel is warranted?
No, that's not what I'm saying.
Okay, thank you.
Thank you.
All right, further questions from the committee? All right, thank you very much, Senator.
Thank
Ms.
you.
Hamilton, thank you very much. Thank you. All right, that'll conclude the hearing for Senate Bill 507. We'll now move on to Ms. Watts. No, because she said she was here for Ms. Watts. Oh, come on, yes. Please, sorry, my apologies.
It's okay, I tend to hide in the corners, it's fine. So, thank you. You know, the testimony you've already heard was very moving. Let me add sort of the lawyer's perspective as somebody who's representing those individuals. My clients with intellectual disabilities who are competent to stand trial, and there are many of them, are really at a severe disadvantage in the carceral system. They are easily manipulated into letting another inmate, for example, make phone calls for them, which is relevant because those are all recorded. And so, you know, those calls get attributed to somebody suffering from an intellectual disability who has little control over what's being said. In terms of the evidentiary issues, in pretrial detention, you know, I can say anything that's true and that I want that will help my client, but the judges aren't required to give any particular weight to it. There's a rule that talks about what they have to require, what they have to consider, and intellectual disability is not currently part of that rule, but there's no statute regarding it. In terms of admissibility at trial, so it's a tricky question because the question is to what are you proposing to show in the evidence? And for crimes of specific intent in very limited circumstances, we could introduce this type of evidence to show that they did not intend the consequence of their actions. But in what we call general intent crimes, the presumption is that you have intended the consequence, whatever it may be, of whatever action you took, which we know is not necessarily true for people with intellectual disabilities. And we are very frequently not allowed to admit that evidence because it's not part of a not criminally responsible or a specific intent mens rea defense. And so this would enable us to say to the judge in a meaningful way that this person did not intend what might to me seem like the natural outcome of a particular consequence. I believe that Senator Henson's testimony or someone's testimony also noted that people often misperceive intent and misperceive the behaviors of people, especially with autism, and that definitely has a negative impact on them at trial. Thank you.
Thank you very much. Questions from the committee? All right, thank you very much. Sure. Sorry about that. Thank you. All right, with that really will end the hearing for Senate Bill 507. We'll now move on to Senator Henson's last bill of the day, Senate Bill 512.
Last bill, colleagues, and I believe this testimony will be just me, Mr. Chair, unless Zainab Chowdhury is here from CARE. Okay. Shanika Henson, Senator for District 30, Annapolis and Anne Arundel County, for the record, presenting, hello, Senate Bill 512, and I am joined by Ms. Chowdhury at the desk as well. This bill is the custodial interrogation of minors' admissibility of statements. It's a simple bill. It simply says that while interrogating anyone who's a minor, our law enforcement officers cannot knowingly and intentionally tell those children a lie and then elicit statements from those children. If they do elicit those statements would not be admissible in court, and that is the crux of the bill. I will turn it over to Ms. Chowdhury. While interrogating anyone who's a minor, our law enforcement officers cannot knowingly and intentionally.
Good morning, members of the Senate Judicial Proceedings Committee. I'm Zainab Chowdhury with the Council on American Islamic Relations, the Director of the Maryland office, here in strong support of Senate Bill 512. My organization is the nation's largest Muslim civil rights and advocacy organization. We believe that this bill establishes a rebuttable presumption that statements made by minors during custodial interrogation are involuntary and inadmissible in court when law enforcement intentionally uses false information to elicit those statements. Senate Bill 512 is a critical step towards ensuring that fair treatment and due process for Maryland's children, particularly Black and brown children, who are disproportionately targeted by law enforcement, is important for us to pass this bill. The use of deceptive interrogation tactics on minors has been well documented, and it has been known to result in false confessions, leading to wrongful convictions and lifelong harm. Studies show that minors are significantly more susceptible to coercion than adults due to their underdeveloped cognitive abilities and heightened suggestibility. According to the Innocence Project and much other documented research, nearly 1/3 of wrongful convictions overturned by DNA evidence involved false confessions, with minors making up a disproportionate share of these cases. Deceptive tactics, such as lying about evidence, such as falsely promising leniency or misrepresenting legal rights, exploit a minor's trust in the justice system and also exploits their lack of experience with the criminal justice system. Senate Bill 512 is particularly relevant to Maryland's diverse communities, including immigrant, refugee, and marginalized youth, who are much more likely to experience racial profiling, the school-to-prison pipeline policies, and police misconduct. And ensuring that a minor's statement is only admissible if obtained voluntarily without deceptive tactics protects constitutional rights and strengthens our community's trust within the criminal justice system. CARE urges Maryland to join states like Illinois and Oregon, which have passed similar protections against coercive tactics targeting minors, and this does not prohibit police from conducting interrogations, but ensures that any statement obtained through deception is subjected to higher scrutiny before it is used in court. So we urge a favorable report. Thank you.
We're going to hear from our guests joining us virtually, and then we'll switch it over to questions for the panel. So Ms. Lamont, Erica, you're up. If you can tab out of your live stream before you come off of mute, that'll help with the feedback.
Okay, thank you. How is that?
Perfect. Welcome.
Great. Thank you, Chair Smith. So good to see you, Vice Chair Wallstrecker, and members of the committee. My name is Erica Lamont. I am the Advocacy Director for Children's Rights for Maryland Legal Aid. Maryland Legal Aid represents thousands of children who have been abused and neglected all across the state of Maryland. SB 512 is a reasonable limit on the admissibility of statements gained from lying to children. Law enforcement officers can still engage in lying or subterfuge to gain information, However, the statement itself won't be admissible unless there is a clear and convincing evidence that the statement was voluntary and not made in response to false information used to elicit the statement. So in addition to having developing brains, our clients have been abused and neglected and have multiple levels of trauma, making them more susceptible to false confessions. Many don't trust authorities. Doesn't lying to children foster additional mistrust in law enforcement? This bill, in its very limited scope, maintains the integrity while attempting to assure public safety. In my written testimony, I've cited evidence, and you can look at that Blacks are overrepresented in samples of false confessions. This is well known compared to whites. And children are even more susceptible to false confessions than adults. So this directly could benefit our clients. While the purpose of custodial interrogation can be to obtain a confession, we must try to lower the chances of obtaining false confessions by limiting the admissibility of statements made due to lies to children. For these reasons, we support and request a favorable report for Senate Bill 512.
All right, thank you very much. Senator Folden has a question, then we'll go to Senator West.
Thank you, Mr. Chair. Hello, Senator. Good morning.
Good morning.
So I guess my question is, since the Maryland Police Accountability Act of 2021, can police currently interrogate a juvenile without an attorney?
Well, no.
Thank you.
Yes.
So that
short answer.
answer tells me that this bill represents a solution to a problem that doesn't exist. Because police can't coerce a false confession because they're not allowed to interrogate juveniles without an attorney present.
I disagree. I disagree that as an attorney who sat next to clients, I don't know that an attorney has an automated control over their client. If the police says something, the attorney likely doesn't know that it's false either. So if the child then responds to that with the attorney sitting next to them, the presence of the attorney doesn't immunize that from happening.
So we're looking for more guardrails to make police not solve crimes while our communities still are victimized.
No.
It's what it seems like. We're allowing them to get counsel before they even answer one question, which is a part of the MPA. Law enforcement cannot talk to juveniles on the street even with a parent's permission. Law enforcement cannot talk to law enforcement on the street during a custodial detention or
Well,
arrest.
that's children who are under, 12 and under. We have those restrictions for them so that they have the opportunity to have counsel present, but the counsel can be present by telephone. It doesn't, I think what you're envisioning is that there's a protector in the room that's immunizing children from making certain statements, or that the person would know that the statement was false. It is limited to certain children, not all. It's certain age groups that are subject to that provision as well. And I do think that if police want to interrogate, the bill still gives them the ability to do it. It even still gives them the ability to lie to children. What it says is that any statements that result from that, you just couldn't admit those into evidence. So a fair amount of investigating could happen.
Again, we have a solution in search of a problem that doesn't exist. But
I
thank you for the
appreciate your
bill.
perspective.
Thank you, Mr. Chair. So I was here a couple of years ago when we passed the bill that prohibits the police from talking to juveniles to try to solve a crime until they've already talked to a lawyer. That was very controversial at the time. And one of the main arguments used in favor of passing that bill was police frequently lie to children, to juveniles, when they interrogate them. And in order to prevent that from happening, we have to require the juvenile to previously have consulted with a lawyer before the police can talk to the juvenile. So that bill that we passed several years ago remains extremely controversial. In the law enforcement community, there is a view that their hands are tied behind their backs in terms of trying to solve crimes involving juveniles, because they can't talk to juveniles, because the first thing that any good lawyer tells the juveniles, don't talk to the police. So it seems to me this bill might provide a compromise would you consider supporting allowing police to talk to juveniles without first they're consulting a lawyer if this bill was passed and said that when they talk to juveniles, police are not permitted to lie to them in order to extract information?
I think your question is premised on a few things. One, that all clients follow all of the advice of their attorneys, and that's not the case for my clients. I know I've given legal advice and people have taken a different course of action. So I think that if our juveniles have the opportunity to consult with an attorney, I don't know that it's going to result in the blanket prohibition on any statements being made to officers after that. As it relates to trading on this bill to open the door on good work that was done by this General Assembly, I'm not in a position to do that.
I didn't think you would be, but I thought I should ask the question.
Fair enough.
Thank you.
Thank you, Mr. Chair. Senator Henson, I'm getting a little confused, so perhaps you can help me out here. What I'm hearing from some of the questions is that law enforcement may not talk to children. My understanding of the law was that law enforcement may not conduct a custodial interrogation of a child. Is that your understanding of the law that we passed as well?
You're absolutely correct, Senator.
Okay, so it is in this custodial interrogation setting that your bill would apply?
You're absolutely correct.
Thank you.
Thank you for the clarification.
Questions from the committee? Further questions? All right, excellent. Thank you both very much. Thank you. Let's see, hold on. Do we have is Paul Ellington going to come up to testify? Oh, that's right. And then Linda Hannafin-Bonner. All right, with that, that'll conclude the hearing for Senate Bill 512. We'll now move on to Senator Augustine, Senate Bill 608.
Oh, gosh. Whew. JPR, boy. Golly, y'all. Are you guys serious in here?
Love it. You like being here.
I know you do. Oh, wow. Good to be with you all this morning. Senator Malcolm Augustine here on behalf of Senate Bill 608. I do have, I believe, Ms. Marquez, Rodriguez, and Mananzan here. Y'all can come up as a part of the sponsor panel on 608. Colleagues, I just want to give a little bit of a background. In 2019, I was a sponsor of legislation to help to streamline the U visa program, but that's been some time since we've done that. So I just wanted to share a little bit about the U non-immigrant status, which is a set aside for victims of certain crimes who have suffered mental or physical abuse and are helpful to law enforcement or government officials in the investigation or prosecution of criminal activity. Now, this was created by Congress, and it's this visa with the passage of the Victims of Trafficking and Violence Protection Act, including the Battered Immigrant Women's Protection Act in October of 2000. The legislation was intended to strengthen the ability of law enforcement agencies to investigate and prosecute cases of domestic violence, sexual assault, trafficking of aliens, and other crimes, while also protecting victims of crimes who have suffered substantial mental or physical abuse due to the crime and who are willing to help law enforcement authorities in the investigation or prosecution of criminal activity. Legislation also helps law enforcement agencies to better serve victims of crimes. And this is very serious in the area that I represent, where we have a number of Marylanders who are fearful, and we want to make sure that they are as comfortable as possible if they are victims of crime, to feel comfortable to come forward. And that's really what these pieces of legislation are about. Now, Senate Bill 608 does a few different things, again, to sort of support this process and also to expand some of the people who are able to participate in this. What it does is it adds some the people who are able to provide who are able to communicate with regard to the certifying agencies, to expand it to adult protective services, civil, family, and or administrative and or prosecutorial folks' jurisdiction, trying to get back to the sense of making sure that we are getting people who are subject to domestic violence, which is a very significant part of concern inside of our communities. It also takes a qualifying criminal activity, which means and ties that more closely to the federal definition, which of course is something that we want to make sure that cross-reference is correct, or complete rather. And it also expands, as I said earlier, who may request this certification, expanding it to attorneys, victim advocates, and other representatives. It also includes in the list of criminal activities, again, we're just trying to make this as inclusive as possible. So it also incorporates sentencing into the list of times that a qualifying participation can be identified. So it includes that into the definition as well. It also makes sure to protect people by making sure that like each qualifying crime or qualifying crime activity will be listed on the certification. Just again, trying to make things a little bit clearer for folks, and then also just to make sure that we have the details of the crime to make it easier for the people who are representing these folks to understand sort of what's going on in that process. That detailed description of the victim's past or present helpfulness, likely helpfulness to detection, investigation, or prosecution, including the sentencing, again, will increase the likelihood of a much stronger certification. And so we want to make sure that we have the strongest certification that we possibly can. There's also language which clarifies that there is no statute of limitations on the request for certification. We want to make sure that we're, again, making sure that we're getting as many people to feel comfortable coming forward and that they're victims of crimes, that they have this process in place. And it also asks that if the certification is denied, that we get a written explanation of why that would be the case, and that you can't just also, and looking at whether or not people have been how they have been participating, just to make sure that you're not just going to take one point at which someone was not, where there was like a helpfulness test that was going on, that they have to consider the totality of the circumstances to ensure, again, that it's not just like one instance where someone might be deemed to be less than helpful, but in the totality that they have been helpful. But as I said, I've been joined by these folks who I would ask Chair Smith if they could share their testimony, and they'd be happy to answer questions. I'm going to ask for a favorable report on Senate Bill 608. You want to stand? Okay. Sure.
Good morning. My name is Amanda Rodriguez. I am the Legislative Committee Chair of the Maryland Human Trafficking Task Force and the CEO of Turnaround, which is Rape Crisis Domestic Violence Center for Baltimore County, City, and Howard County. Mr. Chair, members of the committee, thank you for the opportunity to testify in support of this critical bill, which ensures that victims of crime receive equitable treatment across the state when seeking U visa certifications. Under the current law, law enforcement agencies control procedures for issuing certifications, leading to significant inconsistencies across jurisdictions. A victim in Montgomery County may receive a very different experience than a victim in Baltimore County simply because of where they were harmed. The disparities that this bill will work to address are what crimes constitute or are qualify for certification, how quickly a victim must file for a certification request, and whether victims are notified as to why their certification was denied. Because these requests are entirely discretionary, victims have no recourse if they are denied. There's no appeal process, there's no transparency, and there's no opportunity to correct or clarify information. Without certification, victims are effectively denied their right to immigration relief, leaving them vulnerable and without protection. This isn't just a hypothetical problem. It's happening right now. Just last month, Turnaround began working with a survivor of a brutal domestic violence incident. Years ago, she did everything right. She reported the crime, she cooperated with law enforcement, her attorney, and pursued legal avenues to protect herself. After her case was prosecuted, her attorney submitted a request for a U visa certification, only to have it denied because too much time had passed, according to the certifying body. But time doesn't erase the violence that she endured. Time does not take away her right to safety, and this bill does not change the federal law. It simply ensures that all victims, regardless of where they live, have equal access to relief under the federal law as it already provides. Justice should not be determined by geography, and I urge a favorable report. Thank you.
Good morning, or afternoon almost. My name is Leslie Orloff. I direct the National Immigrant Women's Advocacy Project at American University College of Law. I was actually in the room working with the Republicans and Democrats in Congress writing the U visa, and so I'm happy to be here to support this bill that strengthens Maryland's certification and the certification available to victims. I want to start with the case you just discussed. One of the really important things this bill does is make sure the statute of limitations doesn't interfere with the ability to certify. And that's what Congress wanted to do when it drafted. They put no limitation on the time between when the crime happened and when they request certification. So this bill brings this brings Maryland law consistent with the federal law. Same thing in terms of its including adult protective services as certifiers, following the federal guidance we strongly support. And the federal guidelines, the language in Bill 608 mirrors what other states have done, Utah, Illinois, and Colorado specifically. It also expands to allow victims, attorneys and victim advocates and other representatives, as 6 other states have done, to seek certification, and that and that we really support the strong language in Senate Bill 608 in terms of the helpfulness standard being very closely tracking what the federal law does. And finally, I guess the last point I want to make is we strongly support the provisions as well in Bill 553, Senate Bill 553, that talk about the language access protocols. Thank you very much for the opportunity, and happy to answer any questions.
I feel like we're going to be relying on you as Professor, we're going to rely on you as we move forward with this process. We're admiring your 70-plus page testimony. It was very good. Appreciate that.
Good morning, Chair Smith, Vice Chair Wallstrecker, and members of the committee. Thank you for the opportunity to testify in strong support of Senate Bill 608. My name is Tamara Castro Marquez. I am a senior staff attorney at CASA, focusing on matters relating to immigration services. We thank Senator Augustine and Chair Smith for this bill, as well as the following bill regarding U visa certifications. SB 608 is a critical piece of legislation that strengthens the support system for immigrant victims of crime, ensuring that they are able to seek justice and safety without fear of immigration repercussions. U visas provide essential protections to victims of qualifying crimes who cooperate with law enforcement investigations or prosecutions. By expanding the list of certifying entities, including agencies such as Child Protective Services and Adult Protective Services, this bill ensures that more victims have access to these vital protections, regardless of the government body handling the case. Moreover, this bill clarifies and strengthens the criteria for certifying helpfulness. The provision ensures that survivors are considered helpful if they have cooperated or are likely to cooperate with law enforcement. And this is essential to making the process fair and transparent. This change will prevent unnecessary barriers for survivors who may be hesitant to come forward due to uncertainty about what constitutes helpfulness. Importantly, consistency is crucial in providing a streamlined process for victims who often face overwhelming challenges, including trauma from the crime, language barriers, and fear of deportation. With clear, uniform policies, survivors can better navigate the process, and certifying entities can act with greater confidence that their decisions will be understood and upheld throughout Maryland. By passing this legislation, we send a message that Maryland is a place where justice is accessible to all, regardless of immigration status. And so I respectfully urge a favorable report on this. Thank you.
Thank you very much. Questions from the committee? All right, excellent. We'll be in touch, though, as we work through this, so thank you very much. Thanks. Excellent. Thank you, Professor. All right. With that, that'll conclude the hearing for Senate Bill 608. Thank you, Senator Augustine. We'll now move on to Senate Bill 553.
Okay, thank you, Chair Smith and members of the committee. We will not repeat ourselves because this is a related bill as it relates to the U visa. What I will say is that there are some additional changes that are inside of Senate Bill 553, which I'm going to ask for a favorable report. One is to shorten the period of time, again, for the folks to respond to their certification. That's not requiring them to do it, just that they move a little bit faster. Instead of 90 days, do 30. And the same thing on same thing on the supplemental, that they must receive that back within 7 days of receiving the request. Again, shortening timelines, trying to be as responsive as we possibly can for folks to so that they feel confident when they're engaged in this process. And then finally, certifying that entities shall develop. Certifying entities will develop protocols to assist petitioners who have limited English proficiency to proceed under this section. That is just trying to make it more helpful and more accessible to the folks who find themselves in these circumstances. And I'm going to ask for a favorable report on Senate Bill 553. Thank you. Go
ahead. Good morning again. Amanda Rodriguez on behalf of the Maryland Human Trafficking Task Force. Mr. Chair, members of the committee. The task force is favorable with amendments on this bill. I wanted to start by just thanking Senator Augustine as a wife, a daughter-in-law, a sister-in-law, and a granddaughter of immigrants for his continued support of immigrants in our community, and to the bill's proponent for their commitment to ensuring that victims of crime are treated equitably across our state. We firmly support the intent of the bill and effort to create a fair and consistent process for law enforcement certifications, and believe that collectively with Senate Bill 608, we'd be able to create a stronger unified approach. So our recommendation is that the two bills, really the best of both, be taken into consideration and merged. Victims deserve a system of real accountability, one that does not allow critical decisions to be made in the shadows without transparency or recourse. If we truly want to ensure equity, consistency, and access to justice, we must take the strongest approach possible. We thank you for the continued support in this committee and ask for a favorable report. Thank you.
Ditto is fine too. Pardon? Go ahead.
Okay. I just wanted to add that as we support this bill with amendments as well, I do agree that it's a good idea to put them together. They're the same goal, and that in doing so, it's really important to preserve the federal standard of helpfulness and cooperation, which is in 608, or did I get the number right? Yeah, 608, which talks about the victim. When we wrote the statute, the U visa certification statute, we understood that victims of sexual assault, domestic violence, stalking in particular, that would make up about 75% of all the cases nationally, are people that will cooperate at one point, be threatened, pull back, cooperate at another point. And our social science research shows that they cooperate over time as they become more stable, get more resources, get work authorization and things like that. They get stronger and more cooperative going forward. And so it's really important that the federal standard is, once you provide helpfulness, they cannot unreasonably refuse to provide helpfulness in the future when it's reasonably requested. And that's essentially what's in Senate Bill 608. And so as you merge them, I'm encouraging you to track what the federal laws have done, and we have them in the testimony that I provided to you. So I strongly support this bill and being amended to come together with 608. Thank you.
Good morning, Chair Smith and members of the committee. Again, my name is Tamara Castro-Marquez, Senior Staff Attorney at CASA. In my career as an attorney, I have come across dozens of cases where victims of crime were concerned about their cooperation with law enforcement due to their immigration status. The U visa process, described further in our written remarks, is critical to protecting immigrant survivors of crime and ensuring they can safely cooperate with law enforcement without the looming fear of deportation. SB 553 further adds to this critical process by establishing that rebuttable presumption for helpfulness, helping to ensure language access, and providing a speedier timeline for certification. In particular, the rebuttable presumption element of this bill is a trauma-informed approach that shifts the burden away from survivors, many of whom face language barriers or are navigating the aftermath of severe trauma. This helps ensure fair outcomes and will encourage more survivors to come forward. Furthermore, by mandating protocols to assist individuals with limited English proficiency, this bill ensures that all survivors, regardless of their language skills, can access the protections to which they are entitled, and also feel comfortable engaging with law enforcement throughout the process. As an immigration attorney, I have seen the aftermath of the trauma experienced by immigrant crime victims, such as individuals assaulted at work, mothers whose children face gun violence, and women who suffer sexual abuse. Without the increased protections provided under SB 553, many of these individuals facing crime will continue to remain silent, fearful of interacting with authorities due to their immigration status. And so by passing SB 553, we build trust between immigrant communities and law enforcement, fostering safer neighborhoods for everyone. And so for this reason, on behalf of CASA, I respectfully urge a favorable report.
Excellent. All right, we're going to turn to our panelists joining us virtually. And we'll start off with Erica Lopez. Welcome.
Thank you very much, Chair Smith, Vice Chair Wallstreicher, and committee members. I'm here just to urge a favorable report on 608 and 553, but I would like to step back and will defer my substantive testimony to my colleague, Monica Mananzan, who is an expert in U visas within our organization.
Excellent. Monica, you're up. Welcome. Can we unmute? Hold on. I think you're still on. Monica, I think you're still on mute. 1 second. There you go.
I apologize. Good afternoon, everybody. Chair Smith, Vice Chair Wallstreicher, and members of the committee. My name is Monica Mananzan. I'm a managing attorney at the Amica Center for Immigrant Rights. Previously, I served as a VAWA immigration attorney at Catholic Charities of Baltimore, and I provide free legal representation to U visa eligible immigrant survivors of crime, and have seen firsthand how flaws in the current system creates unnecessary obstacles to their safety and access to justice. Well, SB 553 introduces critical reforms to promote fairness, consistency, and accountability. One key reform, the rebuttable presumption of helpfulness, addresses unjust U visa certification denials caused by misunderstandings, trauma, or the arbitrary exercise of discretion. This presumption streamlines the process and ensures that victims who have not refused to cooperate are protected from inconsistent and subjective certification practices across jurisdictions. This bill also confronts the urgent problem of certification delays, which can have devastating consequences for victims. And for those facing deportation, a delay can mean losing their chance to apply for a U visa, and it effectively strips them of its protection. This not only puts victims at risk, but also undermines law enforcement efforts by discouraging cooperation. And finally, requiring certifying agencies to develop protocols for individuals with limited proficiency is essential. It ensures that language barriers do not prevent eligible victims from understanding and navigating the certification process, because no victim should face additional hurdles simply because of the language that they speak. Without Senate Bill 553, Maryland's system will continue to leave victims unprotected and weaken criminal investigations. This bill provides practical and necessary solutions, and I urge you to support its passage. Thank you.
Excellent. Thank you very much. Questions from the committee? All right.
Thank you.
Seeing none, thank you very much, Senator Augustine. Just, is Viviana Westbrook here? No. Okay, excellent. Okay.
Thanks.
Thank you very much, Senator. All right, with that, that'll conclude the hearing for Senate Bill 553. We'll now move on to Senator Lamb with Senate Bill 577.
All right, good afternoon. So I have members of the panel, Mary Kana from Everytown, and we may have Lisa Shore from NAMI. Lisa, I think, was going to be here for originally this was scheduled for 1 o'clock, and in the switch to the earlier morning slot, I think we're going to try to move her to virtual. I don't know if she's on or not, but she's not on. Okay. Is Mary Kana on? Okay. Oh, there's Mary.
All right, excellent. Who else is
Lisa
on your-
Shore.
Who else is on
Lisa
your
Shore
panel?
from NAMI.
Lisa Shore, okay. She's not here.
She's not on. Okay. All right. Yeah, I think she got lost in the time switch, so sorry about that. Good afternoon. Good afternoon. Chair Smith and members of the Judicial Proceedings Committee. For the record, Clarence Lamb, Senator in District 12, presenting SB 577. So this bill is fairly straightforward. It builds on the committee's work on Jalen's law in promoting safe storage awareness and responsible firearm ownership. This bill requires the Maryland Department of Health to draft literature on gun safety, training, suicide awareness, mental health awareness, and conflict resolution to be distributed by local health authorities and displayed and distributed at the point of service at all stores selling guns or ammunition. The bill does not penalize gun owners or retailers. Rather, it simply ensures that important information is prominently available for firearm purchasers. Any responsible gun owner could benefit from the extra information on gun safety, mental health, or conflict resolution should they need it. Because firearms are the leading means of suicide deaths, it is important that gun owners be informed about this issue and ways that they can take steps to recognize signs of suicide and safely store their guns to prevent unauthorized access. It's also important to note that Anne Arundel County, which I represent in part, has already adopted a similar ordinance, which the Fourth Circuit Court of Appeals has upheld as constitutional. The point of this legislation is not to discourage gun ownership, but really just to focus on promoting mental health awareness and safe firearm practices. And so with this in mind, I ask the committee for a favorable report on this legislation. And I know we have both folks on the panel who are here virtually. Thank you so much. Turn it over to members of the panel.
No, it didn't do this automatically. We'll take our virtual testimony and then questions. Hello, Ms. Kana. How are you? You can unmute yourself and go ahead.
Hi, Senator. Good to see you. Okay. Thank you. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Mary Kana, and I am Policy Counsel for Everytown for Gun Safety. On behalf of Everytown and our Moms Demand Action and Students Demand Action volunteers across Maryland, I'm here to urge a favorable report on Senate Bill 577. This bill would require the Department of Health to create and distribute informational literature for all firearm and ammunition purchasers in the state, including resources for mental health and suicide prevention, conflict resolution, and firearm safety training. It is important that purchasers of firearms and ammunition are fully informed of the potential risks associated with having guns in one's home. The information that will be provided to purchasers on firearm safety and training will help prevent accidental shootings, and having information about suicide prevention, mental health awareness, and conflict resolution will inform gun owners of the resources available to them and their household members in times of crisis or distress. Since the Supreme Court's decision in Bruin, applicants for handgun qualification licenses and wear and carry permits have increased significantly. This underscores the importance of educating purchasers about the risks associated with gun ownership and the resources available in the state. By providing purchasers this literature at time of sale, we can ensure that life-saving information can be put into the hands of each person who purchases a firearm or ammunition. Thank you, and I urge a favorable report.
Excellent. Thank you, Mary. Lisa, you're up next. Welcome.
Thank you. Can you hear me?
We can, yes.
Okay. First of all, thank you for your flexibility as I switched quickly from in-person testimony to virtual testimony today. Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Lisa Shore, and I'm here on behalf of NAMI Maryland, as a person with family members with mental health issues and as a daughter of mental health professionals. NAMI Maryland is part of the National Alliance on Mental Illness, a grassroots organization that supports over 58,000 families and individuals with mental health conditions. They believe that given support and resources, all people can thrive and contribute to their communities. Senate Bill 577 takes successful legislation, which was piloted by Anne Arundel County, and expands it statewide. Anne Arundel County has been a leader in gun safety initiatives with their Gun Violence Prevention Task Force and gun lock distribution through trusted partners such as public libraries. This proposed legislation prevents suicides by providing crisis response and mental health information at the point of sale for guns and ammunition. It is bipartisan, and it provides information without judgment. The United States is facing a suicide epidemic. Suicide is the leading cause of death in people ages 10 to 34 and a significant issue for our veterans. According to the American Foundation for Suicide Prevention, firearms are involved in 50% of suicide deaths, and they make suicide attempts more lethal. Senate Bill 577 provides life-saving information at the point of access to these lethal means without in any way restricting an adult's right to own a firearm. Resources are an important tool in the efforts to reduce suicides and a collaborative way to address this public health issue. NAMI Maryland and I ask for a favorable report on this bill. Thank you.
Excellent. Thank you both very much. Senator West has a question for the panel.
Thank you, Mr. Chair. I think this bill presents a rare opportunity for us to actually come together on a gun bill. That hasn't happened much in the past couple of years. So, Senator, let me read you a small portion of the testimony of Mark Pennick, who will testify, I think, later on. He's back in the committee room against the bill. What he says is, speech such as this may be compelled under the Zauderer decision of the Supreme Court only if the literature is merely purely factual and uncontroversial. He goes on, he says, the constitutionality of the compelled speech authorized by this bill will turn on a case-to-case examination of the content of the literature that is compelled. If the literature is not purely factual and uncontroversial, it will be challenged and struck down. That test is strict. Purely factual and uncontroversial are distinctly different terms and cannot be collapsed into a single inquiry. He goes on. But he says the standard is whether the literature that your bill purports to require is purely factual and uncontroversial. So my question to you is whether or not you're willing to accept an amendment which would add the words purely factual and uncontroversial at this point in your bill. It says the Maryland Department of Health shall prepare literature relating to firearms and ammunition that includes, adding the words, purely factual and uncontroversial information regarding, and then you go on with your list of topics. So my question to you is, would you be willing to accept an amendment which would add those 4 words to your bill?
Thank you for bringing that up. I'm certainly open to that amendment. I think, you know, obviously you're citing the Fourth Circuit case that I referenced as well earlier.
Yes.
And, you know, our intention is that these pamphlets are going to be informational, uncontroversial, just really citing well-documented information that I think is helpful for anyone that might be in possession of a gun for mental health resources, suicide prevention, and the like. And so, you know, I think I'm open to it. This is not intended to give an opinion about firearms or weapons. It's really just kind of
That's
intended
my
to be
understanding of what the
uncontroversial.
import of your bill is.
Yeah.
And it seems to me we can alleviate inevitable litigation if we include these 4 words, and then the Department of Health follows the instructions in the bill and indeed includes information which is purely factual and uncontroversial and therefore would not be challenged.
Certainly open to it, yes.
Thanks.
Thank you, Mr. Chair. Hey, Senator, thanks for coming out.
Sure.
So I just want to make sure I'm reading this correctly. So this is an unfunded mandate that will be passed along to local county governments. Is that correct?
This is a requirement of the Maryland Department of Health to be able to draft literature to provide to local health departments who then make that available to gun store sales.
So the Maryland Department of Health would make the literature, and then it would be incumbent upon all the county health departments to distribute that literature. Is that correct? Okay. I don't see anywhere, and then so each, all right, well, that answered that one. So there's this mandate though would require, I saw somewhere in there's over 700 and some FFLs in the state of Maryland. And some of those FFLs are people that actually just operate out of their home. They have the license to be a firearm. They may be a collector, they may be otherwise, but they have an FFL to purchase firearms directly and then sell those firearms. Mm-hmm. That would include going to these people's homes?
I think those owners or sales, the folks who are selling those firearms could simply have in their possession and provide to those who are purchasing the firearms this material.
Yeah. I understand that part of it. My concern is that the health department's got to go to, all the county health departments have to go, get the literature, and then there's no appeals process. There's no due process mentioned anywhere in this as far as if they don't have it posted, if this were to pass, right? It just says $500 or $1,000. I think 500 first offense, 1,000 for second or subsequent or something to that effect. Is that correct?
Yeah, that's the enforcement mechanism would be with each local health department, but it could be as simple as the Maryland Department of Health coming up with a one-page or pamphlet that's a PDF, and someone could just print it out. Again, you don't have to physically go to pick something up to be able to distribute at the point of sales.
I'm sorry, the last part I didn't follow.
You don't have to physically go pick up a stack of pamphlets. You could have them available as a PDF where the institution engaging in the sales would just print it out and make that available to those who are purchasing.
But they have to do inspections to make sure they have it available in each location.
I think the bill does not require an inspection.
The only way it would be enforceable is if they did an inspection to see if the pamphlets were actually available at each location.
Well, I think if the health department, the local health department wants to do an inspection, they can, but it doesn't require them. This bill doesn't require them to do the inspection.
And so, because you feel that if they do a PDF, that would suffice as the distribution, and then it would be incumbent upon the FFL to print that out and have them post it. Is that?
Yeah, the FFL could print it out and make that available.
And what is the penalty on the? I didn't notice a penalty on. Because that's not mentioned specifically in here as an avenue. If the county health department does not get the information out to every FFL, what is the penalty upon the county for failing to comply?
I don't think the intention is that there's a penalty on the county. The county can print out, the county can also print out their stack. And if anybody wants to come to the county health department to pick up a stack, they can certainly do so, or they can print out their own.
Okay. Thank you.
Further questions from the committee? All right, Senator, thank you very much. Thank you to our panelists. All right, we'll have another panel come on up. Mr. Bellamy, come on up. And then we'll switch to our opposition panel.
Good afternoon, Chairman Smith, Vice Chair Wallstreicher, members of the Judicial Proceedings Committee. My name is Lorenzo Bellamy, and I'm here in support of Senate Bill 577 with an amendment. I'm here on behalf of Teachers Unify to End Gun Violence. Teachers Unify is a grassroots movement of educators and school staff across America educating and advocating and demanding safety from gun violence in their respective communities. Teachers Unify was founded in 2022 in the wake of the Oxford High School shooting in Michigan by 3 public school teachers, Abby Clements, Sarah Lerner, and Sari Beth Rosenberg. 2 of the co-founders survived 2 of the worst school shootings in U.S. history, Abby Clements at Sandy Hook Elementary School in Newtown, and Sarah Lerner at Marjorie Stoneman Douglas High School in Parkland. With over 75 years of teaching experience among them, the founders intend Teachers Unify to fill a gap in the national dialogue around gun violence that doesn't always include teachers. I'd like to thank Senator Lamb for sponsoring this legislation, which we support with one friendly amendment. And that amendment would just be to add, and I think he alluded to Jalen's law, would be to add safe storage to the list of criteria that would be included in the literature. I want to leave you with one statistic. 74% of guns used in school shootings were obtained from the home of the shooter's friend or relative. This is a 2019 National Threat Assessment Center document, Protecting American Schools. It's a U.S. Secret Service analysis of targeted school violence. So we urge a favorable report this bill with our amendment and hope that you will shepherd this bill through the committee. Thank you.
Thanks, Mr. Bellamy, for coming out. I just got to ask you, other than stoking the flames, what does your last statistic have any relevance to this bill?
Well, it's actually was a
74%.
It was a surprise to me that I didn't realize that many.
But it has no relevance on what this bill does, because what you're saying is that the people are getting them from a home and taking them to a school.
It goes to my argument of
wouldn't we be
safe
better
storage.
suited to pass a measure like we were talking about doing a couple years ago, which would be to incentivize responsible gun ownership by giving a rebate or a tax refund on towards a safe or other safe measures within the home?
If you have a bill that would address that, I think we would support something like that as well.
Well, we had a bill there
Well, this
a couple
one
years
doesn't
ago,
talk
and
about this.
It didn't
This bill-
pass, but we're worried about, but I'm just pointing out, you're bringing up a statistic, stoking the flame has no relevance. This is about putting literature in a store that the person would never see.
Correct. I'm not
So-
trying to stoke the flames. I just wanted to bring the statistic up to show what's happening with gun ownership and how they're getting these guns.
Not relevant to this hearing, but thank you.
Appreciate your opinion.
All right, thank you very much. Further questions from the committee? All right, thank you. All right, with that, that will conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel. Is Mr. Jocelyn here? That's virtually. We'll report him in, and then Mr. Penick, come on up first, and then we'll do Mr. Jocelyn.
Any questions from the committee? All right, thank you. All right, with that, that will conclude the testimony. Now switch over to the panel. Is Mr. Jocelyn here? All right, that's for him in, and then Mr. Penick.
Mr. Jocelyn, if you could collapse the browser that's streaming the hearing, and then that'll prevent the feedback. We're going to come to you right after Mr. Penick finishes. Mr. Penick, welcome.
Thank you, Mr. Chairman, members of the committee. I'm Mark Penick. I'm the president of Maryland Show Issue, and for the interest of full disclosure, I was counsel in the Anne Arundel County bill that this bill is modeled after. And we took that to the Supreme Court, and they denied certiorari. So we're faced with Fourth Circuit case law. But let's be clear, and the Fourth Circuit acknowledges this is compelled speech. It is presumptively unconstitutional. There's a narrow exception for it under Zouderer for an uncontroversial and is restricted to labeling or the terms of services on commercial speech. That's it. Now, I don't think this bill survives. Now, if it does only what the man around the county does, then you'll have controlling precedent on it. But I doubt very much that the literature that the State Department of Health is going to be restricted to the two pieces of literature that was issued in that litigation. And if it doesn't, if it goes further, I will challenge it because it's presumptively unconstitutional under the First Amendment. But I wanted to make sure the committee was aware of a practical consideration. You can compel a dealer to post it. You can compel a dealer to distribute it, but you can't make the dealer agree with it. And every dealer who's going to put a trash can in front of his counter and hand it to his customer who's buying a firearm and say, I think this is garbage, you're welcome to throw it away, and there's a trash can. So if you're going to actually successfully communicate with the public that you're trying to address and with these concerns, you need to get the dealers on board, which means you can't be coercing them with big fines and penalties. Make this voluntary. Actually, if you want to prevent violence, you've got to make the dealers be your agents, and no one wants to be a puppet of the state. So I urge an unfavorable report on this bill for those reasons. Thank you.
Questions from the committee? Senator Sidnor.
I just thought we were going to wait until
Okay, that's right. Sorry. Yeah, my apologies. You know, you're right. Mr. Jocelyn, go ahead, and then we'll take questions from the panel.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. John Jocelyn speaking for 2A Maryland. Senate Bill 577, which we oppose, it imposes an unfunded mandate upon 23 counties plus the city health departments. It requires that literature be passed out, literature that covers largely, to a degree, the same topics that are given in the HQL courses and the carry permit courses. The local agencies lack the resources, both financial and personnel, to implement this particular program. It will entail an enormous logistic and enforcement challenge. The fiscal policy recognizes that these problems exist, however, it fails to take into account several of the things. The agencies will have to determine which of these 700 plus FFLs are actually retail dealers. There are many classifications. They will have to determine which is which. They will then have to determine which dealers are in their jurisdiction. And once they've sorted that out, they're now going to be faced with the fact that to sell ammunition, you don't have to be an FFL. When you get beyond the central Maryland, pretty much every gas station, convenience store, hardware store will sell ammunition. This means that they are going to have to individually contact each one of these establishments and impose upon them these requirements. There's no proof that this program in Anne Arundel County even works. We're expected to trust the testimony of those who've gone before me. I would like to see the proof it is in fact efficacy effective. I don't believe that it is based upon my experience teaching. We strongly believe that this is nothing more than an overreach and in essence to make it more difficult to stay in business. We would ask for an unfavorable report. I'll take any questions you may have. Thank you.
Thank you. One, you said that stores will likely put a trash can in front and just have you throw it in. Is that what you're seeing in Anne Arundel County?
I've seen my clients, without speaking for them individually, what they will engage in conversations with their customers about this literature, and uniformly the customers regard this literature with disdain, and it is immediately deposited into a trash can and it goes into the landfill. Congratulations, you've accomplished nothing.
So the next question that I have, given how the court upheld the ordinance in Anne Arundel County, what's the distinction between that and this particular bill?
No, it's actually a copy from what Anne Arundel County is, and it's simply, and that's why if you go beyond what the two pieces of literature that goes on in Anne Arundel County, you're going to be distributing more compelled speech that is also going to be not controlled by that decision, because it's a case-by-case inquiry as to whether this particular piece of literature is in fact purely factual, non-controversial, commercial speech about the terms of service, or a label.
Gotcha.
That's what the holding of the Fourth Circuit was.
Right. So the way that this bill is drafted, you would say that it's constitutional. However, if the implementation is where we would have the issue, have the issue.
I think the Fourth Circuit was wrong, and if there are bills like this in California and New York, those will be challenged in due course. We'll have a circuit conflict, and I'll be right back in the court.
Gotcha. Thank you.
Thank you, Mr. Chair. Can you, I'm curious about your testimony about people throwing it in the garbage and whatnot. Is it your client's position that informing people about suicide prevention and firearm training, firearm safety, mental health awareness is useless, or is it that they don't like that, or is it simply because the government has said this is information we want you to put out?
Well, it's part of all of that. So what we have here is dealers who are being coerced, who don't like being coerced like anybody else, or then have a motivation to tell the customers what they think about being coerced. And the customers, firearm purchasers, are more likely to agree with the dealer than anybody else, and certainly with the Department of Health perspectives on this matter. So it's actually counterproductive. You're actually defeating the purpose.
So I don't think that's really answering my question. So you're saying they are being coerced. So what you're saying is because we have passed legislation that has said your clients must put out information, let's say we were to pass this, on firearm safety, firearm training, suicide prevention, the mere fact that the government has said this is important information for people to have, that's enough. Or are you saying they don't think people should be told about firearm training, firearm safety, suicide prevention, et cetera? Is it that part of it that they don't like?
So,
is information about suicide prevention?
No one has an objection to the government itself coming out and espousing its views about all those subjects. And I'm fine with that. So if the government wants to engage in government speech and First Amendment parlance, fine. What the objection here is basically commandeering the dealer and making them into a government agent against their will.
Okay, can we put away all the inflammatory language and just answer my question? Is the objection that the government has said this information must be put out by your clients, or is the objection, do your clients have an objection to information about suicide prevention?
So it depends on the information that's actually distributed. So there is this assertion that gun owners scoff at, candidly, that a gun emits this certain miasma into the atmosphere, makes a person who's not likely to commit suicide more likely to commit suicide. Nobody believes that. And so any piece of literature that comes out and says that you're more likely to commit suicide in the home if you, in fact, have access to it in the home, it's going to be thrown away. Because nobody believes that. And the dealers don't believe it, and the customers don't believe it. So going to turn very heavily on the content of what's being promulgated. The dealers have no incentive to actually try to persuade people on any of this because the dealer feels like they've been rendered to be a puppet of the state. And nobody likes feeling that way. So if you took this bill and you took out the penalty, at least you would have a chance of persuading the dealer as to the content of what the State Department of Health might distribute. We can have an argument about whether the contents of the distribution is constitutional, and we will have that argument if the state goes over the line. But that is not this bill because you don't know yet what the State Department of Health are going to put out. That's the problem.
I think that was somewhat of an answer. Thank you, Mr. Chair.
Thank you, Mr. Chair. Thanks for coming out and testifying today, Mr. Panic. I wanted to ask you, how many firearms experts does the health department in the state of Maryland have on staff? Do you happen to know?
None that I know of.
Okay, that's interesting. So they don't have any experts in the area of firearm safety or firearm training?
Not that I know.
Okay. So these are clearly the subject matter experts we'd want to craft language around firearm safety and firearm training. I'll get to the mental health part in a minute. I'm just talking about those areas.
They don't know about training. I mean, I know about training because I'm a certified trainer. The dealers know about training because they're experts in guns. Customers may or may not have that training, but I would suggest to you that there's nothing purely factual or non-controversial about training. Yeah, that, by the way, was not in the Anne Arundel County case.
So when it comes to like HQL and CCW permits or training, is there firearm safety and training required to obtain those
yes,
certifications?
By statute. By statute.
So we already have training, and it talks about certain measures, being safe with the weapon, how to handle the weapon.
Yes.
Okay. So does this appear to be more of a mental health advisory that they're trying to put out, which are posted at different places? Because it's clearly not about firearm safety, in my opinion. It's about trying to, I mean, I'm just trying to think of another facet of where government goes and puts advisories in a certain specific sales shop. I mean, I guess they do it with cigarettes.
They do it with cigarettes.
Where they are putting it all over it. But it just seems like this is more of a mental health advisory with people that, you know, cigarettes are known every time you ingest, you're taking carcinogens into your body. Every time I go out and target shoot, I'm just out there plinking targets, plinking steel or others. Am I a mental health advisory necessary at that point? Because every time I pick up a gun, apparently I need to be advised of my own mental health?
The underlying premise of this is a cultural war issue, to be honest, because people who want to make gun owners aware of this information thinks that guns are inherently dangerous and that people shouldn't be having them in the first place.
Correct.
Well, you already have a purchaser who disagrees with that, right? So he's not likely to be amenable to that sort of input anyhow. But if you want to say mental health advisories and suicide prevention, so firearms certainly can be used for suicide, but so can a bed sheet, and they're equally efficacious. Second leading cause after firearms is death by hanging. So you're going to have ropes now having suicide prevention notices for hardware stores or bed sheet manufacturers having to put this out in their literature. It all becomes an exercise in the absurd.
Mm-hmm. So let me ask you this. Is there, when you fill out an application to purchase a firearm in the state of Maryland, or a handgun?
A handgun.
Handgun. And is there any mention in there about your mental health status?
No, there isn't.
Do you have to fill out that you haven't been in, I'm pretty sure there's something in there to ask about, have you been, seen at a psychiatric or a mental health facility?
Oh, yes, there certainly is a in terms of disqualification if you've been confined for more than 30 days, for example.
Yeah, I want to make sure that we're showing that because the young lady that came in and testified earlier and said that because she had been in a mental health facility, self-admitted for over 30 days, it hits in the NICS system.
And that's correct.
And my point being is, when you fill out a firearms handgun purchase form, I guess 77, there's blocks on there that are automatic disqualifiers if you check certain areas regarding to mental health or being institutionalized. Is that correct?
It's involuntary confinement for mental health. It's involuntary or voluntary confinement for more than 30 days. Both are disqualifiers.
Are illicit drugs in there?
Yes, they are.
Do we post any of these signs at the local drug dealers?
No, we don't.
Okay, thank you.
Thank you, Mr. Chair. I'm sorry, I didn't get your name.
Mark Pennick.
Okay. You made some reference to bed sheets. Are bed sheets one of the leading mechanisms by which people commit suicide?
No, death by hanging is.
You mentioned bed sheets, and that's why I'm
bed
asking.
Bed sheets is simply one means.
Excuse me.
I'm sorry.
Let me finish my question. Thank you. You specifically mentioned bed sheets. My question is only about bed sheets, not about anything else. Are bed sheets one of the leading causes of suicide, leading instruments by which people commit suicide?
Only as part of the greater statistics that death by hanging is the second leading cause of death by suicide.
So they are death by hanging. It's your testimony that is primarily done by bed sheets.
No, it's not my testimony.
So it's just some.
There's lots of ways to kill yourself by hanging.
Okay.
That could include bed sheets or rope or any other means that are necessary to do what is accomplished by death by hanging.
So I just want to make clear that your testimony is or is not that there are as many suicides by gun as there are by bed sheets.
No, there are more suicides by death by firearms than there are death by hanging, for sure.
Okay, thank you.
A quick question, it's actually kind of an adjacent issue to this, but you crossed over in Senator Folden's line of questioning. We had a bill earlier today about assisted outpatient treatment. How does that interface with the NICS system? Does it work functionally? Like, how does that?
That seems to be really problematic. The NICS system, the states are voluntarily asked to report disqualifying information into the NICS system.
Yeah.
And if that happens, then the person who goes to buy a firearm will be flagged in the NICS system, but it doesn't address existing possessions or doesn't require them to be dispossessed of existing firearms. So one of the things that dialogue actually brought up was those individuals, and I agree with the PD on this, are not adjudicated to be dangerous unto themselves, at least not as a category. The Rahimi decision talks about individualized determinations of dangerousness as being a basis for a categorical disqualification, and that bill doesn't require it at all. So you're going to run into whether or not you've constitutionally disarmed an individual under Rahimi, as interpreted by the Second Amendment, whether you can do that without an individualized determination of dangerousness. So, and that's actually being actively litigated now in a number of states. There's a current circuit split on 922G3 on whether or not a person who engages in marijuana use is categorically dangerous.
Absent the constitutional concerns, just functionally, is the NIC system even capable of digesting kind of like that half information?
Only to purchases, yes.
Okay. I just don't know the answer.
I brought it up because I've had like a HIPAA issue, because if it's reported, they voluntarily report it. They've actually, I don't know how that doesn't violate HIPAA for them trying to self-administer, get help, and violate because they're reporting because they went in seeking AOT.
There's no diagnosis.
That's a very interesting question about HIPAA, because unlike the application for a license to purchase a handgun, which you have to give up your HIPAA rights, the person who goes through that treatment process is not obligated to throw away their HIPAA rights at all. So I'm not sure there's a reporting requirement there that could be enforced under HIPAA.
Interesting. Okay. All right. Further questions from the committee? All right. Thank you very much, Mr. Pennick.
Thank you.
Thanks. All right. I believe that will round out the hearing for Senate Bill 577. Thank you very much, Senator Lamb. We'll now go on to Senator Folden, and I think we're going to take Senate Bill 532 first.
Mr. Chairman, Mr. Vice Chair, esteemed colleagues of Judicial Proceedings, for the record, William Folden, Senator for representing Frederick County. Before you today, I have Senate Bill 532, and this purpose is authorizing a police officer who's denied a certain right to apply to the circuit court at a certain time for an order that directs the law enforcement agency to show cause why the right should not be granted. This is relative to disciplinary proceedings around law enforcement, and not to, because we've already had quite a lengthy day, I'm not going to belabor the issue. I'm going to step aside and I'm going to let my panel of experts speak on this, and I would ask for a favorable report on SB 532.
Good afternoon. My name is Michael Davey. I am General Counsel to the Maryland State Fraternal Order of Police, and we're also obviously requesting a favorable report on Senate Bill 532. The passage of this bill would allow a law enforcement officer the ability to apply to the circuit court for an order to direct the law enforcement agency to show cause why, under the Police Accountability Act, a right was not granted. A complaint for show cause simply would require a law enforcement agency to explain to the court why they did not follow the law, or at least explain their position. There's really two purposes of the bill. The Police Accountability Act really involves discipline, but there are other provisions of the act that don't involve discipline. So just as an example, if a right under the disciplinary section was not followed, an officer would be able to take that issue to the circuit court, let a judge make a determination of it, and if the judge determines that the right wasn't granted, it could prevent a second trial board from occurring if the department went forward before the issue was resolved. The second part of the law, there are certain provisions under the Police Accountability Act that don't involve discipline. Certain constitutional issues, representation issues, whistleblower issues, secondary employment issues, that there right now under the law, there is absolutely no remedy to. If one of the provisions of the Police Accountability Act has to do with secondary employment and reasonable policies, if a law enforcement officer determines that that the policy is not reasonable, where do we go? Nowhere, because the final say would be the person or the chief possibly who wrote the policy. There's no remedy. There is no way to get around that. That's not something for an ALJ. The administrative law judges strictly deal with disciplinary cases, and what we're finding is even their powers are limited, and I can explain later if I had more time. Thank you.
Good afternoon. I'm Michael Shire with the Maryland Fraternal Order of Police. I've been a police officer for 21 years now. I'm also an attorney licensed practice in the state of Maryland. Thank you, Chairman and Vice Chairman, for allowing us to speak today. I'm going to talk a little bit more about the disciplinary type issues that relate to the show cause order, and we're talking about efficiency and compliance with law. So as a matter of efficiency, the ability for an officer to file the show cause comes in when an agency commits some type of procedural error in the disciplinary process. If that error needs to be corrected immediately, otherwise what you have happen is that you're going to have to go through the entire disciplinary process all the way through a trial board and then go to the circuit court for an appeal on that final decision, and then the circuit court might say, yep, there was a mistake, go back, start over, do this all over again. The analogy would be building a house. When somebody points out, hey, you might have a crack in your foundation, you say, we'll worry about that later. You build the house, and then the home inspector comes and says, yep, there's a crack in the foundation. Tear the whole thing down and start over. That just doesn't make any sense to do that when you can address the issue right away. We've also seen agencies violating some of the provisions of the Maryland Police Accountability Act by illegally suspending officers or imposing discipline without their trial board rights. And currently, as Mr. Davey noted, there is no mechanism to address those issues. A criticism we often hear about the show cause order is that this gives the officers an opportunity to delay the proceedings. I want to say unequivocally that our police officers, when they are under the umbrella of a disciplinary proceeding, they want it over as soon as possible. You get that notice that you're under investigation. They want to get in, they want to do their statement, they want to get through the trial board, and we've even had officers waive various rights under the MPAA just to move things along. There is no speedy trial demand under the Maryland Police Accountability Act. The officers are beholden to the time that it takes the agency to do the process, but by and large, universally, our officers want the process done as soon as possible. They want it done right, and the show cause order allows them to make sure the process is done correctly and without errors so that it can be a final determination. We request your favorable report. Thank you.
Mr. Davey, if you could just come back up. I just want a real quick question. Can you provide briefly, as you can, but a quick example of where this type of order would be important?
So I recently had a case in Cecil County where an officer was investigated. It was determined that he may have violated the policy. It went to the Administrative Charge Committee. They agreed, and they made a recommendation of discipline of a demotion and 20-day suspension. He immediately requested a trial board, and the chief immediately demoted him and suspended him for 20 days prior to the trial board. There is no mechanism for me now to correct that due process violation. Right. So he's now been demoted, lost pay, he's lost 20 days of pay, and there's nothing I can do at that point.
Even though he's still waiting for the process to be complete.
5 months later, we had the trial board. So he lost his rank and his days and had to wait 20-something days. And when I brought that before the administrative law judge, or in this case, it was a retired judge, he said, my hands are tied. I have no jurisdiction over that issue. I am only here to decide whether the officer violated the policy or not. And even if he were to be found not guilty, the ALJ or the the retired judge has no authority to give him his back pay and his back rank.
Right.
So that was why we would like to be able to, before the issue even becomes an issue, be able to take it to circuit court. There have been other issues. I'm dealing with one this week where an officer is on probation. He had a probationary hearing where they wanted to terminate him based on a disciplinary issue. There is no exclusion in the MPAA for probationary officers. When I explained to them, you can't do that. He's entitled to his rights under the MPAA. They're just kind of shook their head, and there's no way for me to get to court ahead of time to prevent his termination.
And there was a provision prior to MPAA for, I guess, was there not, for
yes, under the old LEOBR.
They could dismiss them. Yeah. Basically for calls.
Right, a probationary officer.
The old system.
Correct.
For a probationary.
Probationary officer for any reason could be terminated while on probation, whether it be performance or discipline. However, that's not accounted for.
And that's not how the language is now. Okay, thank you.
Yes. We tried. We tried to bring a writ of mandamus in that situation. And the attorney representing the department filed a motion to dismiss that I could not file this and sue the local jurisdiction or the local government. It eventually worked its way through, but in speaking to the clerk's office, they advised me it would probably take 18 months to get into court.
Mr. Chair, so this sounds a little bit like asking for an interlocutory appeal during the course of a civil trial.
Yes, sir.
And as you probably know, those interlocutory appeals are very disfavored because they would have the effect of putting a whole trial on hold until an opinion of an appellate court could be secured. So have you had any experience in taking one of these show cause orders up to the circuit court, and how long would it take? Could you get into the circuit court like that afternoon and try to schedule a hearing before the judge the next day? Would
really
that work, or are we talking about a long delay here?
I've been doing this for 25 years, and under the old LEOBR, we did have this provision of the show cause. It's really jurisdiction by jurisdiction. Some jurisdictions will get us in 10, 15, 20 days. Other jurisdictions, it takes longer. It really depends on the clerk's office. But what I found in the maybe 10 in my 25 years that I had to file, they moved fairly quickly. But again, that is really based on the clerk's office and the jurisdiction in which it's filed. What we would be looking for is the ability to file it in the circuit court of the jurisdiction where the officer works. And if it was a state law enforcement officer, we would file it in Annapolis, similar to any appeal in a disciplinary hearing.
Would you have any problem if we were to add language to the bill that would require in such a situation the administrative office of that particular circuit court to schedule a hearing before a judge within so many days?
Absolutely not.
Okay, thank you.
Real quick, your mention of the interlocutory appeal, unlike that, the show cause order does not mandatorily pause the disciplinary process under the bill that it has. So if the agency elects to move forward, they might have to do a little bit of a rewind, but there's nothing. So the show cause order does not require the agency to pause the disciplinary process. They can continue to move over. They're taking a chance because if the judge rules in favor of the officer, then they might have to do a little rewind, but it doesn't require that pause.
Senator, just for there is a case on that from the LEOBR. It was Hayden versus the Maryland Transit Administration. It basically states that the department may pause, but they're not required to under the law, and then that they would move forward at their own peril, depending on the outcome of the judge's decision. But it's Hayden versus MTA.
I'm just trying to understand page 2, lines 2 to 4. If the police officer is an employee of a statewide or bi-county law enforcement agency, they can apply to the circuit court for Anne Arundel County. Bi-county law enforcement, pardon my ignorance on this, what does that mean? And does that exclude any part of the state?
No, basically what would happen is if you're in PG County, if you're a PG County officer, you would file that in the circuit court for Prince George's County. Okay. However, if you're a state trooper, a transportation authority, they would have to go to Annapolis, which would be consistent with the law on appealing disciplinary outcomes. We just tried to make the law consistent.
Thank you. I wasn't clear on that. Thank you, Mr. Chair.
Thank you, Senator Muse, because that actually flagged something for me. Are a bi-county law enforcement agency, so our Maryland National Capital Park and Police.
Yes.
So some of them are based in Montgomery County, so they'd have to come to Anne Arundel County?
They would have to go to Annapolis.
Why was that chosen?
That is consistent with the provisions of appeals and disciplinary hearings. The way the law is currently written, that if you are a member of a bi-county jurisdiction, your appeal would go to Annapolis, similar to a statewide law enforcement agency. They wanted to put them all in the same place, as opposed to a Baltimore County would go to Baltimore County, Baltimore City would go to Baltimore City. But because they don't want to keep mixing up the jurisdictions, I believe it was felt that it was cleaner to just put it in one location.
Got it. Thank you. Thank you, Mr. Chair.
Committee. Seeing none. All right. Thank you all very much.
Thank you, Senator.
All right. So now we'll move on. See, Mr. Boatwright is not here. Is that right? He's not here.
No.
Okay. So then we'll move on to the opposition panel. We have Jerome Spencer.
Good afternoon, Mr. Chair, members of the committee. My name is Jerome Spencer. I'm the General Counsel for the Charles County Sheriff's Office. I'm here on behalf of the Maryland Chiefs and Sheriffs Association, and we are very respectfully in opposition to Senate Bill 532. We paused for a second. This morning, the Public Defender's Office and Senator Fulton are on the same page, and now the Chief Sheriff and Senator Fulton are not on the same page. So it's been a very interesting day. We oppose for many reasons. Fundamentally, we want to make very clear the chiefs and sheriffs ultimately, of course, support due process for our officers. We're big fans of that. We want that to happen. But the show cause order, by definition, is a delay. It is a delay tactic. Under the LOBR, when show cause were filed, it could cause delays of a couple days maybe to get circuit court hearing or up to a year to get circuit court hearing. On top of that, there are delays to appellate court and court of special appeals. For example, in Popkin versus Ginsburger versus Popkin, ultimately is a over a 2-year delay because of the show cause proceeding. So that's issue number one. Issue number two, the way the bill is drafted requires the agency to show cause. And to be fair, if we have messed something up, it seems fair to make an agency show cause about that. And yet we have other entities involved, including administrative charging committees, police accountability boards. The agency should not be required to show cause for anything the ACC has failed to do or failed to live up to. And for the most part, I recognize some of the examples Mr. David gave, but concerns about this issue can be raised at a hearing board. There ultimately is a hearing board where these issues can be raised. Most of them at least can be dealt with. You know, every other government employee has to go through the whole process. Every other government employee has to go to their trial before the ALJ to get the holding. As far as I'm aware, there's no other government employee that has the ability to file this pause motion and run to circuit court and say the policy is not being followed, the rules aren't being followed, we want a do-over. And one final observation, my good friend suggested that the proceedings does not have to be stayed. That's certainly true, but as an attorney from my agency, I would never say, let's keep going forward. I don't care what circuit court's going to say. Let's go ahead and take our chances. It does absolutely stay the proceedings until that's resolved. Thank you.
Thank you, Mr. Chairman. So I'm going to try to still be kind of like not too playful with the ball of yarn, you know, but I want to ask you in the situation that was brought up where a chief or sheriff, whoever it was, invokes or administered discipline, a reduction in rank off of the ACC, off of their recommendation. And the person, procedurally speaking, the way MPAA is intended, whether it's being broken apart by the letter or the spirit of it, is that is your appeal, is to go to a trial board.
Right.
And until the disposition of said trial board, that case then is still not fully adjudicated at that point. Is that
correct?
So how is a sheriff or chief able to take an action, reduction in rank 20 days off of the ACC's recommendation when the subject under investigation requested a trial board, which could lead up to and including termination? So I'm not sure how that's a lot permissible, first of all, and secondly, because it's apparently happened, the ALJs on the trial board have no legal standing to make them pay back pay or for the time that they should have still been awaiting a final disposition. That's in every other facet of law. Your appeals process delays any final conviction, right?
Right.
So why is this different for police?
So, I beg your pardon, Senator, why is what part different for police?
So why was a chief or sheriff, whoever it was, why was he able to go ahead and demote and suspend prior to the final disposition when a trial board had been selected? Because when the ACC gives a recommendation, they send it back. They're like, we reviewed this case. Here's our determination, and here's a recommendation that we have, right?
Yes.
And the chief will look at that, or the sheriff will be like, okay, here, supervisor, here, internal affairs, go and give this to the accused.
Yes.
The accused officer looks at it, and he has the opportunity at that time to accept the administrative charging committee's recommendations of punishment, correct?
Yes.
If he accepts it, he signs, right?
Yes.
If he doesn't accept it, he has a block on there that he says, I want a trial board.
Yes.
And he signs there.
Yes.
If he signs for the trial board, is the trial or is the process for adjudication still ongoing.
Yes.
So how is a chief or sheriff able to give a reduction in rank and a 20-day suspension without having a trial or the process of adjudicating charges against an officer until it's been properly through the process?
So I don't know the exact case, circumstances, this is a county case. I know everything Mr. Davey just told us. I know nothing more beyond that. So let's take as a given that the sheriff or chief was not legally able to do what he did. And certainly that would not be the process we would follow. And certainly my agency, if there's a request trial board, we don't impose discipline until the trial process works out. If at the end of the trial board, one thing I think is pretty clear in the PAA, if the trial board sides with the officer and decides there was no misconduct or that demotion was not the appropriate penalty, then I think under the PAA it's pretty clear he is entitled to back pay for that. Now, what wouldn't happen, there wouldn't be a remedy if for the 2 months of premature demotion.
The ALJ has no authority because it's not a part of the statute where they should have been permitted to do the reduction and in the first place. So it's literally a violation of the I'm really blown away that I think you're kind of surprised to hear that as well.
Yes.
That's happened, because I just need you on the record to understand that I'm going to ask you, is that the intended process of the MPAA as you understood it to be, that you're allowed to discipline and remove rank and do a fine or a penalty of loss of pay for 20 days prior to the final disposition of exhausting all available means by the officer?
My interpretation is the same as yours, that the process be followed. In fact, the statute ends with the decision of the hearing board is final unless appealed by the officer. That's the end of the statute.
That's all I need. That's all I need.
Okay,
I get it. That's all I need. I just want to make sure, because mine is the same as yours. So when I heard that, I think we need to kind of get together and have a discussion.
Right. And there certainly may be ways to adjust this bill to talk about ways to remedy that. Our position is where the bill is right now is just too broad, and so it can't be supported as part of it.
Okay, thank you.
Yes, sir.
Thank you, Mr. Chairman.
Further questions from the committee? All right, thank you very much.
Thank you, Mr. Chairman.
Thanks, have a good one. All right, with that, that'll conclude the hearing for Senate Bill 532. Well, now, which one do you want to do next, Senator Folden?
It's up to you, sir.
531.
Okay. Oh, can I do 533? Because then
533, there we go. We got it.
Appointment with the district court in a few minutes.
I'm trying not to get a bench warrant on the lieutenant. Body attachment. I'd like to show the reflection and change of my panel, Mr. Chair. Chairman, Mr. Chairman, Mr. Vice Chair, esteemed colleagues, before you today, Senate Bill 533. For the record, William Folden, State Senator, Frederick County. The police accountability, or under the Public Safety Police Accountability Act of 2021, this bill deals with the time limit for filing charges, administrative charges against an officer. And so there's really two reasons behind this, for myself, for this particular piece of legislation. One is, right now, the intent and what has actually happened in the letter of this law is this is left open because there is no timeline for a year and a day. A chief could go back that comes in later and literally file something on an act that happened 20 years ago. That's not how this is supposed to be, and that's not okay. We shouldn't be changing or creating new carve-outs for disciplinary procedures because Leo Bar is now gone, and by virtue of poor or unintended consequences of draft language, we've created this opportunity for chiefs and sheriffs to go back extended periods of time. The other part of this is the year and a day is something that, hold on, I think I might, the year and a day is a concern where if we have an officer who's charged with criminal proceedings, the law enforcement is conducting a parallel investigation and may, because of this timeline that's very strict in certain manners, create an issue where they would have to be required to give a disposition prior to the criminal case. And I believe that the intent of the law was that once the process of the criminal law has gone through the courts against the allegations of the officer and it is adjudicated, at that point, the year and a day should kick in and start for charging purposes of an officer and not be infinite, but a year and so I think I may have started to misspeak on a separate bill originally in the beginning, but this is an important piece to show that while officers are getting complaints, and if there's a criminal allegation, we want to make sure that that criminal allegation, I can tell you that the department I've worked at had an officer that was charged with criminal activities, and that trial never came to be until about a year and a half later. And as a result of that, the ability to handle and give a disposition through the processes under the MPAA were quite limited and clearly go against the spirit of what that legislation is supposed to do. So with that, I would ask for your favorable report on SB 533. I'll go to my panel.
Thank you again, Senator Folden, for introducing the bill. Mike Shire on behalf of the Fraternal Order of Police. Thank you, Mr. Chair. So two parts of this bill, as the Senator mentioned, placing a statute of limitations for policy violations. First of all, it's important to note that this is for charges that do not involve a member of the public. There's already a statute of limitations on any administrative charge that involves a member of the public. So this could be something like staying coming in late for duty or not having required equipment, missing court, things like that that don't involve members of the public. There's enough lawyers on this committee, I think, to understand why we have statutes of limitations. There's the failure to have statute of limitations, especially on minor charges, means that evidence goes missing, and those things can be held over the head of the possible accused for a long period of time. And in a police department, any kind of political organization, that is just an opportunity for abuse where somebody can hang a charge over somebody's head and just say, okay, I'm not going to charge you with it today, but watch out, you cross me, and 20 years later, as Senator Folden mentioned, all of a sudden that charge comes up against them. And, you know, there are whistleblower provisions in the MPAA, but those are only so useful when you have the ability for somebody to be free of any such minor discipline when that's hanging over their head. That's just too ripe for abuse there. The second part is something that the FOP has supported, which surprises a lot of people, and that is that we want to toll these statute of limitations when there's a criminal prosecution so that we don't mix the criminal prosecution and the administrative prosecution at the same time, because what we have actually seen is the administrative charges have tainted criminal prosecutions, and that's resulted in those criminal prosecutions being thrown out. So by tolling the statute of limitations, putting a hold on it until those criminal charges are completed, you can ensure that justice is done on both sides. And the FOP has been, always has been, and continues to be for proper, fair, and equitable police discipline. And this is just another example of how we have stood up in that manner. So with all of that, we request a favorable report, and I have to excuse myself to head over to district court, so thank you again.
Thanks for clarifying that I didn't misspeak. I just got on the phone.
Thanks, sir.
Good afternoon. Again, my name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we're requesting a favorable report on Senate Bill 533. Basically, this bill is just kind of cleanup language from Senate Bill 670 back in 2021. Under the current law, there is a 1 year and 1 day statute of limitations for disciplinary cases that involve the public. However, there is no statute of limitations for those internal cases where the public are not involved. As Mr. Shire just stated, things like missing court, uniform issues, issues involving supervisors, issues involving officers that don't involve the public. Those can go on for a year and a day, a year and 2 days, 2 years, 3 years, 4 years. And we believe the statute of limitations for those are important, and the law should be consistent. Additionally, as already stated, there has been an issue, and I've seen it based on my representation of officers, where there's parallel investigations going on, one being criminal and one being administrative. The officer is being investigated for violating a law. He's also being investigated for the same behavior as it violates policy. So, and if it involved the public, the problem comes in is the department would have to discipline that officer within a year and a day when the investigation and criminal case may go on beyond that. Just from my own experience, we had a case I was involved in where a few officers were charged criminally. The case administratively went through its process, went through the administrative charging committee, and the Administrative Charging Committee exonerated the officers based on any policy violations. Now that left the open criminal charges, and the state's attorney then had to make a decision, what do I do with that? And eventually those charges were dismissed as a result of the internal investigation. You also then create problems when you have two investigations. If one investigation finds something, another investigation finds the other, and as a defense attorney, that just makes my day. Because then I have the ability to use both of those investigations against each other. For those reasons, we would request a favorable report on Senate Bill 533. Thank you.
Good afternoon again, Mr. Chair, members of the committee. My name is Jerome Spencer. I'm the General Counsel of the Charles County Sheriff's Office here on behalf of the Chiefs and Sheriff Associations. We're very proud here to be supporting Senator Folden's bill, Senate Bill 533. This is a great bill. It's actually a bill you passed last year. The Senate passed this bill 46-0. And there were some issues in the House Judicial Committee that I was there for. It might have been my fault. I don't know. But it addressed the issues Mr. Davey and my other friend from the FOP discussed. Primarily, our focus is on the staying for criminal investigations. Whenever there's a pending criminal, not necessarily a criminal investigation, but potential criminal liability, we always want to contact our state's attorney. State's attorney is what we have before we go forward any further, before we start making compelled statements, before we start putting people on the record. We wait for the state's attorney's office to give us his decision to decline to prosecute or maybe go forward. If he does go forward, there's things come up in the criminal prosecution that help and inform the disciplinary matter. It just makes good practice, good sense to be allowed to delay the administrative proceedings until the end of criminal proceedings. It's a great bill. It eliminates a lot of potential loopholes and flaws in the current system. We encourage, ask for, hope you give a very strong favorable report for this bill. Thank you.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the committee, and a brief thank you to all the DLS staffers for making these proceedings go. My name is Dan Franklin. I'm Chief of Police in Morningside in Prince George's County. I am here testifying on behalf of the Chiefs and Sheriffs Association in support of Senate Bill 533. Coming from a seat of a police administrator, I must say that this is kind of a common sense housekeeping clarifying bill. It tends to be when interpretation is left in an established process that does tend to have rigid guidelines, that tends to be like the little bit of water squeaking out of the pool of the tiny crack. It always goes bad. This is something that will clarify, define, and it will make sure that that process from start to finish is now basically defined, and it has to be followed. I don't want to rehash anything that's already been said, but I do, again, as a police administrator, I agree with all of it. The thing that is most important to me about this one is it gives definition, it is common sense, and it allows for different investigations, when you say criminal and administrative, to be separated, because there are different methods to each one and there are different burdens of proof to each one. Certainly two different processes, although they are similar. Every governmental agency or any other agency that I've been involved in with judicial or quasi-judicial, they all have similar rules like this. For these reasons, I ask for a favorable report from the committee. Thank you, folks, for your time.
All right, we'll hear from Sarah David. Ms. David joining us virtually, and then we'll turn it over to the panel for questions. Good to see you. Welcome.
Thank you. Thank you so much, Mr. Chairman and members of the Judicial Proceedings Committee. My name is Sarah David. I'm the Deputy State Prosecutor at the Maryland Office of the State Prosecutor, asking the committee for a favorable report on Senate Bill 533, also speaking on behalf of the MSA, who also supports this bill. I know time is short, so I just want to highlight some key issues. The first is consistency. As been mentioned, deconfliction in the criminal world is very important. We deconflict with federal partners, other state agencies, administrative agencies, so that we don't duplicate efforts, because those efforts create significant complexities in criminal prosecutions. One of the most serious complexities that comes up in police cases is what come from compelled statements, because in an administrative proceeding, a police officer can be compelled to speak. That statement and nothing derived from that statement can be used in the criminal prosecution because of a Fifth Amendment violation. This causes serious issues for victims, especially in cases involving special victims. Our office recently created a unit to address official misconduct involving special victims. And when we have internal or administrative investigations going on at the same time, that means people are re-interviewed. It also means that they can be tainted by a compelled statement and the prosecution can't go forward. We recently had a case involving minor victims where an officer was having a sexual relationship with minor victims while on duty. The department was cooperative and supportive throughout the investigation and understandably wanted the officer terminated. And we had to go out of our way to create several significant safeguards to ensure that they could compel the statement without it interfering with the trial. If that's not done, then the trial could not have been executed. And so it's really important that this bill would allow officers who commit crimes to be held accountable, both by prosecutors and their departments. Thank you for considering a favorable report on that. And with that, I'll yield for questions.
All right, thank you very much. We'll hear Senator Love.
Thank you, Mr. Chair. My apologies if somebody addressed this, but can someone explain to me why the bill gets rid of the 1 year and 1 day after the filing of a complaint by a citizen and changes it to the date that the appropriate official employed by the law enforcement agency became aware of the incident?
Yes. So if we're dealing with when the complaint is made, complaints are made within a day, a week, a month, a year, 2 years later. That issue becomes a little bit a gray area if the agency was already aware of that complaint. So another officer may have said, hey, yeah, I saw this officer do this, and it didn't require a complaint be written by a member of the public. So it really locks it in a little bit better, that as soon as the agency knows about it, whether it's through a complaint from a citizen or anywhere else, or from a review of body-worn camera, that's the day it starts.
That's very helpful. Thank you. Thank you, Mr. Chair.
I don't see no further questions. Thank you all very much. What happened to this bill? We got this out of here. That's right, that's right. Okay, we'll get it over again.
Thank you.
All right, thanks a lot.
Thank you all.
All right, thank you. With that, that'll end the hearing for Senate Bill 533. We'll now move on to Senate Bill 531. Oh, Sarah, my apologies. Hey, you wanted to come up favorable with amendments on this last bill. My apologies.
I'm sorry.
No, that's on me.
Thank you. I appreciate that. All right, so thank you to the chair, members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support with amendment Senate Bill 533. You've heard why the tolling provision for any instances where there's a criminal case is important. We absolutely support that, and I just want to add that the Governor's Office of Crime Prevention and Policy commissioned an independent report to see how this rollout is going for the police accountability boards and the ACCs, and they said that every single jurisdiction brought that up as an issue. So we're glad that it's being addressed here. We think that's going to help us avoid mistrials and hopefully avoid any sort of erosion of integrity in this process. So we appreciate that. Our only amendment is that we would like for there to be some clarification as to when a law enforcement agency has to hand off an investigation to an ACC, because there have been some narrow sets of circumstances where the ACC is getting the investigation with less than 30 days to do their review. It's only in a few instances, but we want to make sure that the ACC has enough time to make sure that, if they need to issue subpoenas, if they need to request more documentation, that they have the ability to do that, and that a shorter timeline doesn't erode their investigation ultimately. And whether or not that's, 10 months and 1 day or 11 months and 1 day, we're open to that conversation. We would just like to see something that clarifies that so the ACC can do a thorough review of the investigation. So for those reasons, we support with amendment.
All right, questions from the committee? All right, thank you very much. My apologies for that. All right, now we'll move on to Senate Bill 531.
Thank you, Mr. Chair, Mr. Vice Chair, esteemed colleagues of Judicial Proceedings. For the record, William Folden, State Senator, Frederick County. For you today is SB 531, Juvenile Law and Custodial Interrogation, the Juvenile Justice Restoration Act of 2025. In short, this bill authorizes a law enforcement officer to conduct an otherwise lawful custodial interrogation of a child without the child first consulting with an attorney if the parent, guardian, or custodian of the child consents to the interrogation. In short, we have many people, many parents who are frustrated by some of the actions of this body in that they can't even allow or permit or compel their child to cooperate with police on what could be very serious issues, and they want their children held accountable. They're not allowed. It still requires the child to consult with an attorney, and it delays the process, and it's frustrating to some of these parents who want their child accountable for these instances and these actions that they're doing immediately. So with that, I'll just hand it off to my panel, and I would respectfully request a favorable report on SB 531.
Thank you for allowing me to speak. My name is Al Barton. I'm with the Baltimore County Police Department, where I've been a homicide detective for the last 18 years. I'm here to testify in favor of Senate Bill 531. While I understand the intent of the current law, I got to stress that it's made our communities less safe. The reality is that it's effectively done away with the custodial interviews completely. While there may be a case where an attorney has agreed to allow an interview, I don't know of it. Any complete investigation requires effective communication with all parties involved. Everyone should have a say, even the accused. To eliminate the accused takes away the possibility of hearing his or her side of the story. When probable cause may exist for an arrest, many interviews result in lesser charges or no charges at all. There's no way of telling if that's the case without being able to speak with that individual. I'll give you two quick examples of actual cases without getting into the details. We've had an ongoing fatal shooting spree going between two groups. One of the last ones, we speak to one of the individuals involved. It's clear that he knows who the people are in the other group, but is hesitant to say it. There's probable cause that exists for his arrest for other charges. And there's also a concern for his safety and that the safety of his mother and his younger siblings that live in the same house. The mother wants him interviewed and wants to get this straightened out for everyone's safety, but he's under 18. One other real quick one. You have a individual under 18 who shoots and kills another individual who's under 18. There's obviously he's in illegal possession of a handgun, but there's evidence at the scene that suggests the possibility that it could be a self-defense. He's under 18, so we're stuck there too. So in the end, you're left with just the murder by him, or just the death resulting in the handgun, which is a murder charge, as opposed to the potential of having a justified homicide, because you can't get to that point. So in closing, I would say that there are many more such cases as that, but the current rule is failing everybody, including the juveniles themselves. Thank you. Oh, I'm sorry.
Thank you, Mr. Chair, and thank you for coming down today and staying to testify. Earlier, there was a bill that related to custodial interrogation of juveniles, and the suggestion was made that police are at liberty to discuss things with the juveniles on the street so long as they're not in custody. I know that the legal standard about whether or not you're in custody is a very subjective one and deals with whether the person feels that they are at liberty to leave. And I've always been told that because the standard is so subjective and because there's always going to be an objection, the police do not feel at liberty to discuss anything with any juvenile under any circumstances in light of this law until the juvenile has talked to an attorney. Is that your impression about how things work on the street?
I would say not 100%, honestly. I mean, we still talk to juveniles on the street, but once you get into the potential of a custodial situation, then it just doesn't exist. We just don't do it because we don't want to cause problems down the road.
Okay, thank you.
Thank you, Mr. Chair. So in the case that you mentioned, where the mother wanted the child to confess or talk to law enforcement or whatever and was frustrated, she was still able to talk to her child about the pros and cons, correct?
Correct. And just to clarify, it wouldn't have been a confession. It would have been providing information, but he would definitely be in custody at the time that the interview took place, so it would be a custodial interview.
Okay, so under this bill, her wishes would take precedent over the child's wishes.
I would say that it just eliminates the problem we have with inserting the attorney component that we can't get past. We would love to go and abide by the mother's wishes, but we're just not able to do that.
Because the child is allowed to have an attorney.
Because we're required to do both. It's not just up to the mom, it's up to both.
Right, right. So currently, I'm trying to make an analogy here. A defendant has a right, an adult has the right to an attorney, correct?
Of course.
Okay. Now, a child does too, based on the law that we passed.
Always has, even before that.
So, if I'm understanding this bill correctly, the mother, notwithstanding the child talking to an attorney and the attorney advising the child not to talk to the police, the mother can waive that and compel the child to talk. Is that what the practical effect of what this bill would do?
No, no. And in fact, let me give you, without getting into detail, the last case that I was discussing, because it's improper in a public hearing. Okay. I will tell you that that's a situation where that mother didn't have that kind of control over the son and didn't have the ability to say, you say it right now, you tell us what's going on. She didn't have that control. He operated on his own. She was more concerned about her own safety and that of the kids in the house. What we were hoping to do was, with her consenting to his interview, we would then go to him. We'd still read him as Miranda. We'd still read him all of his rights, which would include the attorney, but he'd have to make that decision whether he wanted to speak or not. So all those rights still exist.
The bill on page 3 says the child's parent, guardian, or custodian consents to the custodial interrogation of the child without the child's consultation with an attorney. So that child would not have counsel.
Yeah, I didn't write the bill, and I'm not an expert on what exactly it says. I'm sorry.
So the purpose and intent of that is that the parent, in the situation he's giving, where they're worried about retaliation by a rival gang, they can say, hey, you can talk to him now. Like, we don't have to wait. We want to get it taken care of. So the child can then, if he chooses to, but he still has to be advised. If he's a suspect, he still has to be advised under Miranda. If he's not a suspect, but he's there because they're investigating a case, he can then speak freely with the officers, or he still has the right, or he or she still has the right to say, you know, because of Miranda, yeah, I don't feel comfortable, I'd like to have an attorney. But if the parent says, hey, I'm here, I'm with my child, and I'd like you to talk to him, it may be something that either the parent wants to get it solved, or the parent has, it'll make the child feel better that the parent is there in that, because the parent doesn't disappear when they talk. The parent's still allowed to be with them.
But if the child doesn't want to talk and has told law enforcement they don't want to talk,
then they don't talk to them.
But this says that the parent can override that and consent to the custodial interrogation.
They can consent to it, and then the child can still say, I ain't got nothing to say to you.
So
it's not saying the parent can compel them. It just says the parent can give consent for you to talk to them. That's the difference. That's the main difference.
Okay, thank you.
Thank you, Mr. Chair. Thanks for coming out.
No, I mean, yeah, Senator Walsh-Trigger has a question, then I have a question too, but, so, go ahead, Senator Walsh-Trigger.
I have a question for the detective, excuse me. So I think you and I are on different sides of this issue, but I share Senator West's concern that perhaps people with less experience or less expertise than you may be interpreting what we consider to be a relatively narrow law in a way that is more broad than we intended, and that harms investigation. So, right, you're a detective, you've got a lot of experience. That's not true of every officer on the street. So how can we help you, your department, other departments? How can MPTSC help make sure that the limited nature or what we intended to be the limited nature is the training in the department, so that investigatory questions and questions that are non-custodial in nature can continue to be asked, and we can help make sure you solve the crimes that you need to solve.
I'm sorry, you're saying that are non-custodial in nature? Correct. I don't believe that's a problem. Yeah, I believe that we're still doing non-custodial interviews just like we did. The problem is we're not clearing nearly the number of cases that we used to, and certainly not at the speed that we used to for the ones that we can clear, because we're handicapped by the attorney rule. That completely changed how we have to operate and how effective we can be, and clearly made it less safe on the streets because we can't take that immediate action that we used to be able to take.
Okay. Senator West.
Follow up for a second. So a policeman's on the street and is talking to a a juvenile who has direct knowledge about a crime, and the juvenile implicates himself, makes an admission. Isn't it highly likely that when the trial occurs, the juvenile's attorney is going to say that that conversation was the product of a custodial stop, and that my client didn't feel he was at liberty to leave, and therefore that statement that he made is disallowed and will not come into evidence because the state did not follow the law and get him a lawyer before he talked to the police? Isn't that what's going to happen?
I think, as you mentioned before, there's a fine line between non-custodial and custodial interview.
Yes, I understand you're very experienced and I'm sure well educated in such matters, but the policeman on the street, the information I'm getting is from regular cops on the street, is that their basic view is we can't talk to juveniles until they get legal counsel, or else whatever they tell us could be thrown out in court.
I would say that the officers that you're referring to, which would be the newer members of our agencies that are on the street, are very nervous about making a mistake and are very hesitant to do some of the things that we're discussing, because there is such a fine line of when it transitions from a non-custodial to a custodial situation and then kicks in all these extra rules that have been placed.
Okay, thank you.
All right. Further questions from the committee? Okay. Excellent. Thank you.
Thank you.
All right. We'll now hear from the opposition panel from Marlon Tillman, Frank Pentanella, and then Evelyn Walker.
Hi, was someone called before me? I didn't hear.
Oh, yeah, they're not here.
Oh, okay. Ready when you are? Okay. Good afternoon, Mr. Chair, Vice Chair, and members of the committee. My name is Frank Patnella. I'm a senior policy advocate with the ACLU of Maryland. We oppose Senate Bill 531. We worked to pass the Child Interrogation Protection Act back in 2022. We're advocating that it remain unchanged because of the protections that it provides for children. First and foremost, the Miranda rights of a child is the child's right and the child's right alone. Parents and guardians can certainly be there to support their child if they are in police custody, but they should not be able to provide consent for the child to waive their rights. Secondly, studies have found that children don't have a firm grasp on the legal implications of their Miranda rights, which is why we support the requirement that law enforcement contact an attorney or a public defender for a child before an interrogation. An attorney can explain complicated legal terminology in age-appropriate language so that the child can make an informed decision. Also, please use scare tactics and intimidation during interrogations, and studies have found that children are much more likely to falsely confess under that kind of pressure, as much as 3 times as likely to falsely confess than adults. The research also shows that adults on average don't have a strong understanding of their Miranda rights. Allowing parents to give consent to an interrogation of their child might sound like a good move, but they are simply not qualified to advise their children about the risks of waiving their rights. And if a parent is allowed to give consent to an interrogation, that is added pressure on the child, which will increase the likelihood of a false confession, which will not improve public safety, and it could negatively affect the investigation. Lastly, the current SIPA law allows law enforcement to interrogate a child without contacting an attorney first if they reasonably believe the child has information about a serious threat to public safety. For these reasons, we ask for an unfavorable vote on Senate Bill 531. Thank you.
Good afternoon, Mr. Chairman, Vice Chairman, and members of the committee. My name is Evelyn Walker, and I'm an attorney with the Maryland Office of the Public Defender in the Juvenile Division here in Annapolis. The Maryland Office of the Public Defender respectfully requests that the committee issue an unfavorable report on this bill, which would allow a parent or guardian to waive a child's right to be consulted by counsel. Overall, the Child Interrogation Protection Act, SIPA, must remain as written to protect the constitutional rights of Maryland's children. Evidence suggests that the presence of a parent neither increases juveniles' assertion of their rights or mitigates the coercive circumstances inherent in police interrogations. Many parents are unaware that their presence or participation in their child's interrogation can fail to protect their child's right against self-incrimination. Every child has a right to understand their legal rights and protections, and this cannot happen unless they are properly advised by a lawyer. As an attorney who works on the Youth Access to Counsel Hotline, I am trained specifically on how to advise children and objectively assess a situation and help a child understand their rights and make a choice about whether or not they would like to speak with officers. This bill would allow a parent to waive their child's right with no regard for what the child wants or needs. Children are entitled to legal protections as individuals, separate and apart from their parents, and parents cannot replace legal counsel for a child, especially when a child is accused of a delinquent act. To allow parents who may be scared, confused, angry, or even alleged victims to override their child's right to counsel would be detrimental to the children across the state and unconstitutional. A constitutional right cannot be waived by a person who doesn't hold that right. To ensure that any waiver of these rights complies with the Constitution, we ask for an unfavorable report on this bill.
Thank you, Mr. Chair. So let's just be clear. There is no constitutional right on the part of anyone to talk to a lawyer before voluntarily talking to a policeman. Isn't that correct?
If there is a custodial interrogation, you have a right under Miranda to be advised. And what I
You have a right to be advised.
Sure.
But the current Maryland law requires a juvenile to consult with a lawyer.
That is
is not a constitutional right, is it?
You do, yes, that's correct.
Thank you.
We're not. We could go down this rabbit hole for. We've had this conversation for a couple of years now. But just so you're on the hotline early on in the early stages of implementation of SIPA, like you heard a lot of rigmarole about the hotline. How's that going now? I haven't heard anything for months, so I assume it's all functioning well. But I wanted to give you an opportunity to tell us how it's functioning. It's 24/7. How's it going?
I was actually on staffing the hotline this week. I finished my last shift last night. It's going well. The hotline is operating as it should, 24 hours a day, 7 days a week by attorneys with the Maryland Office of the Public Defender. And I know that there was some discussion about how, people don't know whether or not children are invoking or not invoking. And I can say there are examples of children who have made a decision to speak with police officers with a counsel present. I can give an example. very, very generally, that there has been a child that I have advised that decided to speak with the police, and it worked out well for everybody involved, and the answers to the police's questions were answered.
Thank you, Mr. Chair. You jogged my memory here, so I appreciate you. So speaking of the hotline, can you tell me how many people are, like, it's 24-hour?
Yes.
So how many people are on that hotline at a time or available? How many attorneys?
So during after-hours shifts, there are 3 attorneys that staff the hotline.
3 attorneys on staff for the whole remainder of the
Yeah,
the
so
night.
we staff essentially weeknights and weekends. There's 3 attorneys that are on the hotline at that time. During business hour shift, there's 1 attorney that works.
Now, do you guys do this voluntarily?
You can essentially sign up voluntarily for the hotline, but you are compensated when you work on the hotline on after-hour shifts.
So what does it cost the state taxpayers to have us have attorneys be paid for 3 during the remaining 16 hours where there's not 1 available, or every other attorney in the daylight available? What does it, do you know what it's been costing the state to staff 3 attorneys 24 hours a day, or the remaining 16 hours a day for 365 days a year?
I don't have that information, but I'm happy to get that information to you.
Do we know how many calls you've gotten during those overnight hours also, all those off hours in the same year?
In this year, I don't have that information off the top of my head. I can say anecdotally, we normally get anywhere. I will tell you, this week when I was on the hotline, there were no calls that came through for my evening shift. I'm not sure about business
So no
hour shift.
calls.
But there are usually, I would say there are usually calls.
So is this a contracted amount that you guys get, or is it just a set amount regardless of who volunteers for it? Like, what is the amount per hour that one attorney gets paid to be on call? And I'll put that up in the air because, like, you were on call, but it's not like you were sitting at a desk in a room just watching a phone waiting for the light to come on.
That's true, but I do,
like,
essentially, we have obligations that we have to follow. So for example, I have to have my phone on me at all times. I have to be able to remove myself from any type of situation that I'm in. I have to have it on loud.
Yeah,
with the buzzer on, essentially, so that we essentially have to be able to answer a call at any time.
Do you get like a hotline phone, or do you still use
We
your
have
own
to
phone?
use our own personal phone, but it comes in through a hotline. There's essentially a phone number that's called, and it connects through a tree to our phone.
So it requires you not to drive anywhere, just be available.
We may have to drive for an in-person advice.
I'm saying to just staff during those times.
Yes.
So like for you, you didn't get any calls, but you were available for whatever, an 8-hour shift or whatever it is.
Yes.
What's the hourly rate of that?
I can say that there's a spectrum. So if you're attorney number 1, who's the number 1 responsible attorney, I believe I cannot remember off the top of my head. I can send all of that information to you.
I mean, is it like $50 an hour? Is it $100 an hour? I mean, you attorneys, you guys got to get your pay. I mean, you guys paid for a lot of law school.
That's true. I believe it's around, for the week or for what the hour shifts are. So for my week, I believe it was for attorney number 1 around $700 for the week total. But again, I'm not positive as to the specifics, but I'm happy to send that information to you so you can have all of it.
Yeah, I'd appreciate it because I'd like to know like that tiered amount, because if it's $700 a week for one, and then you multiply that out times 3 plus the person during the day times 52 weeks. I mean, I don't know if you've heard, but we got a bit of a budget crisis here, and we're not violating anyone's constitutional rights. We're just adding counsel availability at what would seem, with you not getting any calls this week, at a pretty hefty expense to the taxpayer. So, thank you.
Further questions from the committee? I'll also note that when we passed the bill, the fiscal note said that you all could handle it within existing resources.
Yes.
All right. All right. All right. Thank you all very much. That will end the hearing for Senate Bill 531. Well, now, Senator Fulton, that's the last one, right? No, yeah, we're going to do. We've got a last one for you. That's all I was asking.
Oh,
Yeah. All right, so let's go on to Senator West is going to present for Senator James, the Senate Bill 548.
Hey, you me on my panel? Terrific. So I'm wondering whether Judge Dumais is supposed to be here, I think, but by video. Great, okay, terrific. All right. Well, Mr. Chair, Mr. Vice Chair, I am not Senator James. She's under the weather today, but I handled this bill last year, and she took the bill this year. And so I think I know pretty much what the bill is all about and can present it correctly. So it's a pleasure to do so. And if Senator James is watching on Zoom, hello. So, over a decade ago, the General Assembly established a Commission on Child Custody Decision-Making. The Commission met over 90 times and spent literally thousands of hours analyzing and discussing the testimony of leading experts in a variety of disciplines related to children. The Commission's final report set forth 10 guiding principles that should govern child custody decisions, the first of which was as follows: the need for a Maryland custody decision-making statute providing a clear, consistent, predictable, gender-neutral process guiding custody determinations for litigants, lawyers, and judges. Under current Maryland law, judges make their child custody decisions based upon factors set forth in numerous appellate court decisions handed down over a period of many decades. Some of these rulings are not necessarily reflective of modern demands of parenting. In addition, some judges rely on different cases than other judges. So child custody decisions are not always consistent from one jurisdiction to another. Furthermore, while most family law lawyers and all judges deciding child custody cases are familiar with the relevant case citations, in some jurisdictions in Maryland, as many as 80% of custody cases have one or both parties appearing in court on a pro bono basis. In those cases, low-income litigants who cannot afford an attorney are at sea, as the cases on child custody are inaccessible and are difficult for a layperson to understand. So this Senate Bill 548, right, is the response to the Commission's final report that was issued nearly 10 years ago. For the first time, it pulls together and codifies in statute in one place the 16 relevant factors that a court must consider when deciding child custody issues. Once this bill is enacted, this information will finally be easily accessible to judges, attorneys, and litigants, no matter their personal financial circumstances and whether or not they are represented by counsel. The bill is written in plain English, so the relevant factors can be easily understood by lawyers and laymen alike. Factors for the child's well-being the court may consider include the child's foreseeable health, the frequent, regular, and continuing contact between the child and parents who can act in the child's best interest, whether and how parents who do not live together will share the rights and responsibilities of raising the child's relationship with each parent and any siblings, their physical and emotional security, and the child's developmental and day-to-day needs. The final factor is, quote, any other factor that the court considers appropriate in determining how to best serve the physical, developmental, and emotional needs of the child, close quotes. Unlike the previous versions of this bill, Senate Bill 548 primarily consists of the list of factors. It does not put its finger on the scales by weighting one or more factors more heavily than others. Everything is left to the court's discretion, but the bill requires the decision of the court to be set forth in writing or on the record. The only other component of the bill is a provision stating that the court may modify its child custody or visitation order if the court determines that there has been a material change of circumstances that results in a situation in which such a modification would be in the best interests of the child. Such a provision is only prudent. This is a reasonable and responsible bill that simply implements the recommendations of the Commission and makes the law in this area accessible to everyone, no matter your personal circumstances. Under the circumstances, I appreciate the committee's consideration of Senate Bill 548, ask for a favorable report, and turn the proceedings over to Judge DeMay and to my other witness, Laurie Ruth.
Excellent. We'll go to Judge DeMay first. Judge, welcome. Good to see you.
Thank you. Good afternoon, Mr. Chair and Vice Chair and members of the committee. It's my pleasure to have the opportunity to speak to you today about Senate Bill 548. As Senator West indicated, and we've indicated a couple of times before, the legislation is the result of the Commission on Child Custody Decision-Making. It was a legislative commission that was established in 2013, and we finished it sometime in 2014. I was privileged to be a member of the commission, as was actually Lori Ruth, who's going to testify in a few minutes too. It was probably the most comprehensive commission that I've ever worked on. Although the commission had maybe 25, 26 members, we brought in over 200 people in the way of having a number of subcommittees to work on different aspects of custody decision-making. The bill actually tracks Maryland Rule 9-204.1 and 9-204.2. One of the other things that was the result of the work group was these rules actually provide that when there's a custody case, parents have to provide a parenting plan. And these list of factors, as well as other important information, is handed out to all people involved in custody cases. As many of you know, I'm currently sitting on the Circuit Court for Montgomery County. I practiced family law for over 32 years. I'm actually currently the Montgomery County family judge in charge, whatever that means. And I sit on these cases. I'm on the family rotation. When I draft my opinions in custody cases, I want you to understand that my opinions usually are, sometimes I give them orally, but if written out, they're at least 15 pages. And I cover each of these factors, partly because I know about them, and most of my colleagues do. And that is what the law should require. Parents need to understand why judges make the decisions they make, but more importantly, when they're presenting their case, they should know what the judge is looking for. And that's the reason why this bill is so important, because it's an additional place where this list of factors will be. And I hand them out, to be honest. I had a case just last week. It was a pro se litigant trying to explain to me why he should have custody. He had no idea what he needed to present. I actually handed him the list and asked him to please try and testify on those factors. That's why this is so important. This bill passed the House last year. The time crunch that I am unfortunately very aware of after my 19 years in the House of Delegates, the bill didn't get through the Senate. We're hopeful that maybe this year we can get it through the Senate as well. I do think it is really a good consumer bill, and it certainly would help so many of the pro se litigants or self-represented litigants that can't afford an attorney, and it would just help them present what I need in order to be able to make an appropriate decision. Happy to take questions when Ms. Ruth is done.
Excellent. Thank you very much, Judge.
Excuse me. Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Lori Ruth, and I'm the Public Policy Director at the Maryland Network Against Domestic Violence. I'm not really here so much in that capacity today, although we did put in written testimony supporting the bill. I am also a member of the MSBA Family Law Section Council, and since this is a repeat bill, only there were a limited number of witnesses who were allowed to testify. So I know that legal aid is also in support of this bill. I think the most important part from my experience at my prior employment, as some of you know, I worked for almost over 15 years at the Women's Law Center, where we operated the family law hotline and received 6,000 to 7,000 calls a year on that hotline. The largest proportion were questions about custody. We kept those details for our grant funders. And legal aid also has a hotline that gets family law calls, and if they were here, they would be testifying. They get these calls all the time. I cannot think of a reason not to pass this bill. The fact that it would require judges to put their reasoning and what factors they considered on the record is very valuable for litigants who sometimes this is their only interaction with the court. And when a judge comes out and says, well, I heard all the testimony, I'm ordering custody this way, they don't have any idea what has happened to them. And so I think that's a really strong point about this bill. It does address both physical custody and legal custody, which is important. I commend you to the Family Law Section Council's written testimony, which was written by Michelle Smith, who, as I said, was not selected to testify, but it does have important information in it. It will bring Maryland, if you pass this law, in line with the 42 other states that have codified factors. You know, we have codified factors for alimony, which is a much smaller portion of family law cases than custody, and it only makes sense to me that there's a place in the law that we can refer people to. And it is a child-focused bill that maintains the best interests of the child approach rather than putting the thumb on the weight, as Senator West said. And just briefly, thank you, Senator West, and I'm sorry Senator James is ill, but I appreciate that you were here to be in her stead. And for those reasons, we urge a favorable report. Thank you.
Excellent. Thank you very much. Questions from the committee? All right, seeing none. Thank you very much.
Thank you, Mr.
Judge DeMay, thank you very much for your perspective and for your time today. Thank you.
Thank you.
All right. With that, that'll end the hearing for Senate Bill 548. We'll now move on to Senator Charles, the Senate Bill 565, or you want to do 521? Which one do you want to do? Yes. I don't. Are they here for the hearing? Are they? We have special. Are you all from a certain school or? Girl Scouts of Central Maryland. Hey, well, we're gonna welcome the. Stopped in to say hi. Yeah. We'll stand. There you go. The Girl Scout, stand up. There you go. Welcome. Hey. Welcome. You've got some consumer. Yeah. Thin Mints, baby. Why am I not surprised you're like a connoisseur? You know all the Samoas are the jam, man.
Somebody brought in 3 boxes of Thin Mints. No Samoas. What's happening? Tag-along.
Samoa's the coconut ones?
Yes.
Everyone likes coconut.
Everybody loves coconut. Samoas are big. You don't go to a body like this by McDonald's alone. Girl Scout cookies. That's
So Girl Scouts of Western Maryland? Central Maryland. There you go, Central Maryland. Welcome.
All right. Mr. Chair, for the record, I'm Senator Nick Charles, and I'm testifying here in support of Senate Bill. You guys have a seat. Also, Senate Bill 565, which is the Mateo Green Law, mandatory blood alcohol concentration testing for drivers involved in fatal or serious injury motor vehicle accidents. This bill mandates the BAC testing for all drivers involved in motor vehicle accidents resulting in fatalities or serious injuries in the state of Maryland. This legislation is named in honor of Mateo Isaiah Green, who tragically lost his life in a fatal crash in April of 2024. It aims to address a critical gap in Maryland's current traffic safety policies and improve public safety outcomes. In Maryland, blood alcohol concentration testing is inconsistently applied. The mandate for BAC testing applies only when reasonable grounds for impairment exists, placing the decisions to test largely in the hands of the investigating officer, something we believe is a cumbersome burden. For surviving drivers involved in fatal crashes, Maryland lags behind other states. The absence of a mandatory testing policy means many alcohol-impaired drivers may go undetected, hindering efforts to hold offenders accountable and implement effective preventative measures. Comparatively, states with mandatory BAC testing policies for all drivers, such as South Dakota and Utah, achieve much higher testing rates and greater transparency in fatal crash investigations. The tragic death of Mateo Green on April 7th, 2024, underscores the urgent need for standardized BAC testing in Maryland. The crash, which resulted in 1 fatality and multiple serious injuries, exposed a critical gap in the state's law. There is no requirement for mandatory BAC testing for all involved drivers. As a result, the determination of alcohol impairment is left to the discretion of the investigating officer, leaving crucial questions unanswered and potentially allowing impaired drivers to evade accountability. Implementing the standardized testing would ensure transparency, consistency, and justice, which is most important in such devastating cases. States with mandatory BAC testing laws have demonstrated the effectiveness of such policies and reduced alcohol-related crashes and fatalities. In New Mexico, mandatory BAC testing combined with public awareness campaigns has led to a 100% testing rate for fatally injured drivers, contributing to a significant decline in alcohol-related fatalities over the past decade. Similarly, Hawaii enforces robust policies with the 97.3% testing rate for fatality injured drivers. Ensuring consistent enforcement and a reduction in impaired driving incidents, South Dakota also mandates BAC testing for all drivers involved in fatal accidents, achieving an 85.4 testing rate, which enhances accountability and supports data-driven interventions to improve roadway safety. Approving Bill 565, Mateo Green's law, this will establish Maryland as a leader in traffic safety and alcohol-related crash prevention by enforcing key provisions that enhances accountability and data-driven decision-making. The law mandates BAC testing for all drivers involved in accidents resulting in fatalities or serious injuries, ensuring consistency and enforcement. It also sets up a standardized testing window, such as within 2 hours, to guarantee accurate and reliable results. This legislation will promote transparency by developing a comprehensive data collection system to analyze trends and information for future public safety strategies, ultimately strengthening efforts to reduce impaired driving incidents. Senate Bill 565 mandates this testing for all drivers involved, and we can honor Mateo Green's legacy, save lives, and create a safer future for Maryland's communities by enacting this bill. I urge this committee to favorably vote for Senate Bill 565. Now, please kindly welcome the family of Mateo, who will speak to the devastation and the trauma the current law has allowed to take place. I greatly appreciate their willingness to come and share their story to fight for a better Maryland and to honor Mateo's life. We have here today his mother, Ms. Sherelle Green, and his sister, Ms. Kristen Green.
Good afternoon to the members of the committee. As the senator stated, my name is Sherelle Green, and this is my daughter, Kristen. It is truly by the grace of God that I stand here before you today on behalf of my family in support of Mateo's law, named after our youngest child and only son, Mateo Isaiah Green. As I said, here with me is his big sister, Kristen. In a recent article published by CBS News, a Maryland state trooper was quoted as saying that driving under the influence is a choice. In that same report, AAA noted that in 2023, there were nearly 5,500 crashes involving impaired drivers, resulting in 132 deaths and nearly 2,500 injuries. On April the 6th, I received a late-night call, one that no parent in this room would ever want to receive. Our son had been in an accident, was unresponsive, and flown to Baltimore Shock Trauma with severe traumatic brain injuries, where he was put on life support. The next day, after many tests, the doctor pronounced our beautiful son, brother, grandson, nephew, and friend brain dead at the age of 23, with an entire life yet to live. According to the statistics, according to those statistics provided by AAA, there's a problem in Maryland. There are far too many drivers failing to make the right choice. The founding mother of our church has coined a phrase, choices are long-lasting and life-changing. I believe driving under the influence is a choice, and I venture to say it's a premeditated crime. The driver makes the choice to drink and get behind the wheel, putting others in jeopardy, causing crashes, resulting in injuries and/or death. Let's not delay these offenders the consequences they have earned. Please support Senate Bill 565 in honor of our son and the others in our state who may suffer the loss of a loved one at the hands of a driver who makes the wrong choice. Thank you.
Well, thank you, Senator, for bringing the bill, and Ms. Green, and just thank you for being here. Like I said earlier, it's always tough to get down to Annapolis. It's hard to come stand before a committee. It's hard to come stand at that podium, but it's even more difficult to share a personal story. So I just appreciate you taking the time to do that to make sure that Maryland's a better state tomorrow than it is today. So thank you very much for your testimony.
Thank you.
Questions from the committee? Excellent.
Thank you.
Thank you very much. All right, so with that, that will end the hearing for Senate Bill 565, and we'll now move on to Senate Bill 521. So the Girl Scouts in the room who are about to leave, just thank you for taking time to see us. As you got a little sample of a lot of the subject matter, and sometimes it's a little more difficult, so thank you all for being here.
Yeah. You know, Mr. Chair, I probably should have had the Girl Scouts here for my bill about custody and having access to both of their parents on a consistent basis, because we all know mom and dads are equally important. So, but I know they're about to go off and go get us some cookies.
There you go. Oh, wait, Senator Folden might have something for you out there. Is he out there yet?
All right, I'm going to ask that my
Senator Folden might have
panel.
something for you if you're out there, but yeah, maybe. All right, yeah. Oh, there he is.
All right. I'm going to ask that my panel join me here at the table, Dr. Frank Malone from the 100 Fathers Incorporated, and Mr. David Smith from the Children's Rights Fund. We also have attorney Tisha Hillman, who's not a part of the panel, but she's incredibly passionate and has over a decade in family law. So I'd like to have her up here for you as well. Good afternoon, Chair Smith and Vice Chairman Wall-Striker and the honorable members of Judicial Proceedings Committee. For the record, I am Senator Nick Charles, testifying in support of Senate Bill 521. This is a bill that we have already heard. This bill has been put in multiple times, year after year after year. Senator Muse has been a sponsor of the bill. Senator Jill Carter has been a sponsor of the bill. I have been a sponsor of the bill. We have cross-filed. We have done it from the House to Senate, and we've all sat on this committee together in support of this particular bill. This bill establishes a rebuttable presumption in child custody proceedings that joint legal custody and joint physical custody for approximately equal periods of time are in the best interest of a child. It still authorizes the court, however, to award sole custody based on reasonable and significant evidence that a joint custody arrangement is not in the best interest of a child. This bill is about ensuring our custody courts are truly operating under what will be most advantageous to Maryland families. If there is not sufficient evidence shown that one parent cannot contribute to the best interest of the child, what is the basis to limit the access that a child should have to both guardians? By embracing joint custody arrangements, we acknowledge the importance of both parents in a child's life. Published in the Journal of Family Psychology by the American Psychological Association, children in joint custody arrangements had less behavior and emotional problems, had higher self-esteem, better family relations, and school performance than children in sole custody arrangements. As we hear countless bills this session and ideas about how to transform the lives of our juveniles, I truly believe that we must put more focus on fixing our family court system. This bill is not just about the legalities. It's about the emotional well-being of our children. By promoting joint custody arrangements, we're not just ensuring fairness in the courtroom, but we're also giving children the opportunity to maintain strong bonds with both parents. It's about creating stability. It's about creating security in both of their lives, something that every child deserves. There are multiple states in our country like Kentucky, Minnesota, Missouri, Florida, Delaware, which already have enacted this law. It's time for Maryland to step forward and recognize the importance of starting at a 50-50 point for both parents, instead of having one side fight for their right just to spend time with their child. For the record, we've submitted an amendment to this bill that would align this bill with the bill that Senator Muse submitted back in 2017, Senate Bill 905. It takes into account the language terminology, changing the technical definition that has been implemented into family law since 2016. I urge a favorable report, and I am honored to turn this over to my incredible panel that I brought together today, who have collectively spent decades. I was just telling David earlier when we used to come out here when little Nick was just a baby, and Mr. Chair, you remember when I brought him to your committee when you were just a young delegate at the time? David actually had hair then, and now he's missing hair and all of his beard is gray. So we've been doing this for quite some time prior to me getting here in office, and it's about time for us to get this bill passed. So I'm asking that we give a favorable report to this bill so that David doesn't have to come here with a walker next time. Thank you, Mr. Chair.
Good afternoon to this distinguished body, Mr. Chairman. I'd like to recognize Senator Muse, been a part of this fight. My name is Dr. Frank Malone. I stand before you in the spirit of David Levy and Judge Arthur Burnett, who was our chairman of the board, who has since passed on. The fight continues. I would like to give honor to this body of legislators today, because today we have the opportunity to follow the lead of the Honorable Wes Moore, who 2 days ago gave the blueprint for how to begin the healing that is needed for the families of the state of Maryland. In his speech, he mentioned fathers, men, and boys. For years, we've stood before legislators who've been blind to the understanding that parent means team. The governor's state of the address focused on the importance of fathers, men, and boys in the context of the missing ingredient that can help to heal our families, bring safety, love, and connection. Over the years, we've requested equal opportunity for fathers as well as mothers to love our children. So the question is, who is the best parent? That answer I will give you now. The best parent is both parents. Today, many states recognize the best interests of the child is vested in both parents, who can demonstrate equal love, equal caring. Their means of growth and guidance is unique to each child. It is time for this great state to step up to the 21st century, recognize the need of shared parenting, and bring the family healing that is necessary. I ask you, legislators, now to make that this reality for the state of Maryland.
Thank
you
Thank
for
you.
this opportunity to address this great body.
Excellent.
Mr. Chairman.
Thank you.
Thank you, sir.
Greetings, Chairman, Vice Chair, and committee. You know, it's great when I have a team like this because they make my job much easier. I feel like a ghostwriter when I have to come up here. So I'm David W. Smith Sr. I am the co-founder of the Children's Rights Fund and the vice president of the 100 Fathers. And I've been supporting this effort for a decade, as Senator Charles said, back when the one and only Jill P. Carter brought it to the House floor many years ago, and been fighting ever since. And mind you, that commission that we talked about that Senator West brought for James was actually a result of Senator Carter and I creating that commission on child custody decision-making in 2014 so that we could find solutions behind the problems. And so as that commission went through, and it did good, and I commend Dorothy and Dumais for their testimony, but there are some things missing. And in 2015, there was recommendations, like we did say, into terminology change and policy changes. And that bill was a lot bigger than it was now. So it's been cut down quite a bit since 2015. But what Senator Muse did when he, in 2016 with that bill after the commission, made it very clear that this is what we need. And so as states have passed many laws around shared parenting, I have a report card here from the National Parents Association. The state of Maryland is ranked D- on their family law statute. That is below average failing. And so they titled Maryland as a deadbeat last state because they're in their family law statutes. And so that's facts right there. And so as we focus on forward moving, like Dr. Malone said in his speech, and like the senator said, we have got to find a baseline that is going to secure the best interests of our children. And I know our opposition is going to come up here and they're going to talk about the domestic violence and the abuse, but that's all been debunked. Shared parenting does not increase abuse, domestic violence, or any of that. It actually protects the child and allows safeguards in place for children. So as I wrap up, because I saw the time end, I urge a strong favorable result and a rebuttable presumption of shared parenting so that we can get back on the list and not be at the bottom of the list. Thank you very much.
Okay, thank you. All right, questions from the committee? All right, thank you all very much. Thank you, Senator. So that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. We'll report back in Judge Dumais and is Michelle Smith here? All right.
I don't think we knew she had been selected. I wish she had known, but she.
Well then, Miss.
Told she was not selected.
Okay. Are you? Can you stand in? Do you want to or no? All right. Well, let's go ahead with Judge Dumais and we'll wrap it up.
Okay. All right. Well, thank you again. And again, good afternoon to the committee and the chair and vice chair. I'm Kathleen Dumais. I'm a judge in the Circuit Court for Montgomery County. Practiced family law for over 32 years. And now I'm on the family rotation in Montgomery County and actually handle these kinds of cases. My practice was entirely family law for 32 years. So one of the things I wanted to sort of start with is what existing Maryland law says. And family law article, section 5-203A says, parents are the joint and natural guardians of their minor children. So under current law and practice, courts approach this from the perspective of both parents should be involved. There is no one that is in opposition to this bill that does not believe both parents should be involved. The question is, what should the standard be? And what should we be looking at? And I believe, and so does the family law bar, that it should be child-focused. We operate under the best interest of the child standard. And that's the lens the court has to look through. The court stands in the shoes of the child. So each case is different. And that's the reason we need the custody factor bill, so that everybody understands what it is that they should present. I don't know what report Mr. Smith was referring to, but if we get the D-, it's because we don't have a custody statute. I do ask you to look at the Family Law Section Council's testimony, because I commend Michelle Smith. She had her staff basically do a 50-state review of what the statutes look like across the country. What cases or what states might have a presumption, which ones don't, and how they're drafted. And you'll see that not that many actually have a presumption. We, as judges, look at this as what's best for the child. It's not always a 50-50, and it shouldn't be putting people in a position of need to overcome this. There are cases where the schedules don't work. Maybe they live separate, in separate states. That might be, but nothing in this bill says that that's what is going to overcome the presumption. I will also tell you that where this is going to play out is in the court most of the time. In my practice, and as I think Ms. Ruth can testify and everybody else, 80% of custody cases resolve. The cases that are before the court are the hard ones. They're the ones where, for whatever reason, they were not able to come to some kind of a conclusion. We've got mediation set in place for cases. There are all sorts of ways to resolve it. And when they don't get resolved, there is something going on between the family. And to suggest that we have to start from the presumption that it has to be 50-50 just isn't practical. And more importantly, is not child-focused. And that's what we believe it should be. The law does already acknowledge both parents, as it should. I will tell you that both in my practice and sitting on the bench, I absolutely believe both parents should be involved. And that's where we start. What's best for this child? What are the circumstances? And again, the bill that you just heard, one of the very first factors really is frequent and regular continuing contact with both parents. That's critical. So I'm happy to eventually answer questions if there are any. I don't want, you all have had a long morning already, so I'm going to turn it over to Ms. Ruth, but I do suggest, and not just suggest, I highly recommend you look at the Family Law Section Council's written testimony, and particularly the analysis of the statutes across the state. Thank you.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. Once again, I'm Laurie Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence. I've been here a long time too today. And once again, I am also on the Family Law MSBA Section Council. We oppose this bill. Both of those organizations do, or committees or whatnot. We believe that the best interest of the child is the best standard. And if you do look at the Family Law Section's testimony, you'll see that even states that say something about a presumption, underneath it often say in the best interest of the child. And so when we've looked around at other states, there's not really a large number, or I don't know how many it might say in the testimony, that actually use a presumption. I don't think presumptions overall are a good idea. This one, I think, puts the needs and wants of the parents over those of the child, and that's what we've testified about for years. Family law is not one size fits all, and that's what this presumption bill is trying to do. And it just does not reflect the reality of every family's situation and how different it can be, and what works for one family does not work for another family. And you're also putting people who are often in the economically inferior position and may be victims of domestic violence in the position where they have to provide proof to overcome the presumption. From the network's perspective, that's the most dangerous part of this presumption bill. And so, not to belabor it, I agree with everything Judge Dumais said, and we urge an unfavorable report. Thank you.
Thank you, Mr. Chair. This question is for Judge Dumais. How you doing there, Judge?
Good, how are you?
You liking the new job?
I do enjoy my job.
That's
hard.
good.
I will tell you, and particularly in custody cases, but I do.
I believe it. Well, my questions are about your statement on frequent and continuing contact.
Sure.
And I do agree. I know Virginia has that that's a part of the Virginia statute, the frequent continuing contact measure. What is your definition of frequent and continuing contact?
It depends on the case. So in most cases, I will tell you that if the parties are living in the same geographical area, and then I'm going to do a schedule that acknowledges that. But you're looking at, can both parents get the child to school on time? Are both parents available, whether it's after school or after daycare or whatever the case may be? Kinds of cases where sometimes you have to be creative. Maybe you've got 2 firefighters or 1 firefighter. Maybe you have 1 police officer. And that's why, again, it's really that each case is different. Frequent and regular contact to me means that both parents should be involved in that child's life or children's lives absolutely as much as possible. A lot of my cases I do resolve at close to 50-50, sometimes 50-50. But I also ask, and I have to admit, I didn't really get this until I served as a best interest attorney for children in a case probably 25 years ago. And both parents wanted 50-50. One of the things that I actually asked the parents to think about is think about your child. And I really understood this when I became a legislator and was staying in Annapolis during the week and then going home on weekends. Sometimes with a 50-50 schedule, what we're asking the kids to do is move back and forth between homes every 2 nights, sometimes week to week, depending upon the age. But I often ask the parents that ask for that, would you like to live that way? Now, that is not to say that both parents shouldn't be very involved, but there are lots of ways to be involved with your child, and that's what, as an attorney, and even now as a judge, I ask parents to consider. You can have shared physical custody and maybe not have the exact 50-50 overnights. Maybe you're the parent that coaches all the time. I had a client who, one of the things he fought for, and we got, as well as lots of overnights, but he wanted to continue to take his kids to school every day, because just with them in the back seat, he learned more in the time it took to take them from home to school than he probably did any evening when they were involved in their phones or whatever the case may be. You have to be creative. And most of the lawyers that I know, that either appear before me or when I was practicing, we try to be creative to include frequent, regular contact. Can I give you a specific definition? No, because each case is different. And that's really what Ms. Ruth said, what I've said for years, the same number of years you've been interested in this bill, the same number of years I've opposed this, but I absolutely believe in parenting plans. And I absolutely believe in parties working together to come up with schedules that work for their family. That's the key. And it doesn't require a presumption that it has to be 50-50, that somebody has to overcome. The facts are different, and it should be child-focused.
Another question. And, I'd like to thank you for the work that we were able to do on getting rid of the child support cliff and changing the definition of joint custody from 128 overnights to the 92 overnights, which allowed to take the fight of money out of the conversation and make it more about the children.
Critical.
I truly appreciate working with you on that. But now that we have this 92 overnight and we've taken the money out of the fight, we've gotten rid of the cliff, for the consistency, have you seen an increase in, as a judge sitting in your particular seat, seeing an increase in the amount of joint custody arrangements that have been approved by the court? Have you seen that?
I think there has been an increase. Certainly an increase. Can I tell you with specificity that there are more that are 50-50? Maybe not, but I will tell you that more and more of the cases that I see are more, at 120 overnights. Or, most of the cases I see now are above the 92, the magic 92 or 98. You think I'd know that, but I don't remember if it's 92 overnights or 98 overnights where we, start moving into the child support area to take into account that the parent that has 92 overnights has expenses, and that's what getting rid of the cliff was about. But more and more of the cases are closer to the 128, 130. Family law is evolving, and really has been over the last 20 years, but certainly since the Commission on Child Custody Decision Making, because we have tried to change the language. We don't talk about you have custody and you have visitation. And I've said it before, in my practice, from the day I started 32 years ago or 35 years ago, I didn't use the word visitation because I don't think any parent visits with a child. They have an access schedule. They have residential access for this amount of time, and the other parent has residential access for this amount of time. But the key to me is that each family is different. We have to take those differences into account.
And another, thank you, Mr. Chair. And so, Judge DeMay, is it safe to say that in your role as chair, not chair, but as a judge, that most of these cases come to you because folks cannot come to an agreement and there's some level of fighting?
Yes.
That's taking place?
Yes, and as I said, most cases settle. I mean, at least between 80 and 85% of family law cases settle for lots of different reasons, and whatever. But the cases that get to me are those that couldn't come to a conclusion for whatever number of reasons, whether, differences in opinion about how many overnights. But I know that most of my colleagues, at least here in Montgomery County, I'm looking to see how do I make sure both parents have frequent, regular access.
And my last question to you is, as you deal with these cases where the fighting comes, how often do you see a parent asking for shared custody when the other parent is filing for sole custody?
You know what, that's a good question. And what I have seen more and more, and in the last 10 years that I practiced in that, and I've been on the bench 3, is more and more people ask for some form of shared. Do I still see complaints that ask for sole? Sure. But what I actually see on both sides is asking for shared. Maybe they have particular things they want to distinguish. Maybe one party is more available after school, but they do talk about, I want shared custody. I see more and more cases where people are asking for longer weekends instead of get the kid after school on Friday, bring them home on Sunday, and that's all you get. What I'm seeing is, let's do the alternate weekends, but it should be maybe Thursday to Sunday or Thursday until Monday morning when they return the child to school. And then on the weeks that it's not their weekend, that there should be at least one overnight. That's where we're getting up to the anywhere between 92 to 130 overnights. More and more cases I see are sharing custody in the summer on a week-to-week basis. Because they're, sort of at the point where if we're both working, it's, sort of good that the kids have a place, are able to see both parents. But again, you've got to go through all of those different factors. Where do they live? Where is camp if it's summer? Can both parties participate in it and get them to and from school and our camp? What's their sports activities? Are both parents going to participate in the extracurricular activities and make sure that they get to their activities on their time, if this is an activity that's important to the child? So, when I'm fashioning the 15-page decision or more that I talked about earlier, all of that is pulled out in my opinions as to, this is the testimony I heard. Dad doesn't think, or and I don't want to do a gender thing. One of the parents doesn't think the kid should be involved in football, period. But maybe there's a best interest attorney representing the child that talks about how important football is to the child. I'm going to take that piece into consideration, that maybe a parent that supports football should have the child on the days that football is involved. Music is the kind of thing we see. So, each case is different. That's why we have to make sure the litigants know what they need to present and what's important for the court to be able to make a decision.
And my last question to you is still centering around the same question I just asked previously. when you have those, because it's very few and far between, but those are some of the most egregious cases that come before you where you have to make a hard decision, where you have a parent that's asking for shared and another person is asking for sole. What typically, like, how are you, because I know you've probably heard about 3 or 4 of those since you've been in your seat as a judge, at least 3 or 4, because those are the most contentious cases. You know, it's, if one party is asking, it's almost biblical when you think of the Bible, one party is asking for, I want to spend equal time with the child, and the other side is saying, I only want the child, I want the child all the time, the other person should not have any access. But one is saying, let's share, the other saying, I'm going to be selfish and I don't want to share. How do you deal with
The one that doesn't
that?
want to share, it better have a really good reason, because that is not, number one, even if, we don't get to a place where we have a custody statute, which I think we should, that lists these factors. There is already case law in place that I'm looking at the factors that are in the different cases. Primarily Montgomery County v. Sanders, there's Taylor v. Taylor, long list, and all of the factors that we are trying to get codified are in these cases. So I'm starting from the perspective of, if you think that you're gonna not cut a parent, you're gonna cut a parent out, you better have some really good reasons. And the other parent then has the opportunity to explain to me why they should be involved in that child's life. And I'm gonna look at all of the factors that are in these cases that I would like to have in statute and make a decision. But I will tell you, absent evidence that the parent, that a parent is posing an imminent danger to the child, and that's also covered in our law already, I am probably going to provide access. If there is some cause for concern, maybe, and again, these are really hard cases where maybe there's been a mental health issue, and maybe there has been a threat of violence to the child or prior abuse, then we start with supervised access. We don't cut it off. It really has to be incredibly severe before a parent's not going to have access to a child. And absent those really extreme cases, it's really, how do I share the time the kids have with the child, with both parents?
Thank you, Judge. I'm happy that we both agree that at least shared time and continuing frequent time. I know we differ on how we get there, but I'm happy to see that, over the 12 plus years that we've been advocating on behalf of this bill, we finally hit some headway where we found a lot of agreement. So I'm pass it back to the chair. Thank you.
Thank you.
Thank you. Hello, Judge. How are you?
Hello, how are you?
Good to see you.
Nice
Next
to
question
see
comes from Senator Muse.
Okay.
Your Honor, how are you? Good to see you again.
I'm good. Nice to see you too.
Thank you. Thank you. Just a couple of questions. You said 80% of most cases are settled, but that's not the case. That may be the case in Baltimore, but it's certainly not the case in Prince George County.
I'm not sure of that. I mean, there are the cases that get to court are the hard ones.
Right,
Okay.
right. And would you agree that we have a presumption in child support?
There is a rebuttable presumption in child support that the child support guidelines are correct. That is, you are correct. That is the way the law is drafted. And that simply means that the whole reason for that is because we want to make sure that child support is implemented in such a way as, there's not, somebody doesn't have a stronghold. Like an economically dominant spouse doesn't say, I'm not going to pay child support, but I'll give you X. The reason the guidelines are in place is because it's based on income shares. What is your income? We plug it into a formula. Money is very different than the factors that you have to look at when you're talking about custody.
So what rebuttable presumption just says is that each parent, when they walk in, start at 50%. Why would that not be, why would it be okay there, but not okay in custody cases?
Okay, and it's because custody cases should be child-focused. What's best for the child? The rebuttable presumption and the child support guideline is about making sure that all child support cases or all child support calculations are done the same way and are fair based on income and not based on one parent having power over the other. That's the reason there's the rebuttable presumption in child support. There we're talking about parents, and we're talking about income, and how do we make it fair all across the board? The difference in custody is that we're talking about the kids. And we're looking at, and that's why we want the factors to say, each case is different. Let's look at these factors and figure out what works. Without a presumption that something's correct, when in so many cases, it may not be.
And I think that in both custody and child support, both should have the child centered. And all this says in the center. And all this says is we start here, and the judge can say, one goes up, one goes down, but they start there. And I'm trying to figure out, as I have for years, what's the problem in saying they both start at 50%, and you, as a judge, can look at it and determine if it stays at 50 or goes up or down. And I appreciate your answer on the child support, but I don't agree with that, but I appreciate your answering that.
Well, and I understand. And again, you and I have had this conversation. I know we disagree, but I do think that it's different. Custody is different than money. That's the real difference.
But it just makes it seem like money is most important. Well, okay. Thank you, and thank you.
Thank you.
It's like money is more important than custody. To have it in one, not the other, says that. Well, in my opinion, it does. Thank you.
All right. Thank you.
Thank you, Senator Muse. Thank you, Judge. Any further questions for any of the opposition? All right, seeing no questions, thank you both. Judge Dumais, I don't know if that's an image or your real background, but I see Chairman Valeri.
That's my real office with all of the stacks of cases I have to write opinions on, but yes.
Well, I noticed less so the cases than the fact that you appear to have the chairman's gilded coin over your shoulder, which many of us have in our offices. So I noticed that and I'm appreciative of it. So thank you, Judge. Have a wonderful weekend.
Nice to see everyone. Have a great weekend.
I think that concludes the hearing for Senate Bill 521. We'll now move to our last bill of the day. Senator McKay, if you're ready, with Senate Bill 454.
I just push the play when I do?
Yep.
Awesome. Thank you. Well, thank you, Mr. Chair. Thank you, committee. Mike McKay here to present Senate Bill 451. Now, this bill will prohibit the Department of Juvenile Services from knowing or hiring or retaining an individual who has been convicted of any of the following crimes unless judgment of conviction for the crime was reversed or vacated. Abduction, kidnapping, manslaughter, except involuntary manslaughter, murder, rape, sexual offense in the first or second degree child abuse, sexual abuse of a minor, felony sex trafficking or forced marriage, continuing the course of conduct with a child, first-degree assault or assault with intent to murder, rape, or commit a first-hand sexual degree sexual offense. The Child Victims Act of 2023 passage has brought much attention to the Department of Juvenile Services, and I feel the need for Senate Bill 454. You may or may not have been in your feed of your social media, and in your social media there are tons and tons of ads informing the public similar to this.
An issue affecting some of Maryland's most vulnerable youth, abuse within juvenile detention centers. These facilities, meant to rehabilitate young offenders, have instead become sites of profound abuse and mistreatment. Juvenile detention centers, often referred to as youth detention facilities or juvenile halls, are designed to house young people under the age of 18 awaiting criminal trial or serving out criminal sentences. And research shows that these centers have alarmingly high rates of sexual victimization, often surpassing adult prisons. For example, the Backbone Mountain Youth Center in Swanton, Maryland, has the highest reported rate of juvenile detention center sexual abuse in the nation, with a staggering 36% of incarcerated youth reporting experiencing sexual abuse while in the facility, triple the national average. The systemic physical and sexual abuse in Maryland juvenile detention centers is not isolated to this one facility. Across Maryland, media reports and lawsuits have surfaced detailing decades of physical and sexual abuse in at least 10 different facilities around the state, affecting countless lives from at least 1969 to the present day. Many of these impacted individuals, already survivors of considerable trauma, find themselves re-traumatized rather than rehabilitated. And these cases of abuse are predominantly perpetrated at the hands of staff members, including correctional officers, guards, and other facility staff. If you or someone you know has suffered physical or sexual abuse in a Maryland juvenile detention center.
Thank you for allowing me to play that clip. We all understand the problems at DJS. And I think it's very, very important to note this is not a Moore administration problem. This has happened for multiple administrations, and this has no reflection upon Governor Moore's administration. However, it is time that we take a look and we pass Senate Bill 454, because in the fiscal note, in the analysis, it does say where there is no statute that specifically align with the provisions of the bill, DGS is required to conduct employment-related criminal background checks. Obviously, the current law has not protected these children in our custody, and horrible actors have been employed. For these reasons, I urge a favorable report of Senate Bill 454.
Thank you, Senator. Senator Love.
Thank you, Mr. Chair. My apologies, Senator, if I missed this. Where is this clip from, and who is the woman that was speaking?
So this happened to be something that was on YouTube. I do not have the name of her, but she does represent a particular law firm that is looking to take on cases. That's why I stopped it before that, because I didn't think it was fair that this is some form of an advertisement. This bill has nothing to do with an advertisement of them, but I thought that she was able to shed light of the problem that has existed since 1969.
Got it. Thank you.
Thank you. Any further questions for the sponsor? You know, I would just add something like this happened in Montgomery County Public Schools, and this bill made me think of it. I know the bill does not apply to schools; it applies to juvenile facilities. But we had a teacher, a first grade teacher, who was dealing drugs, and I think her drugs ended in the death of someone else. And I was curious about that, because you'd think the school system might know, and it turns out she was convicted for multiple drug offenses prior to being hired by the school system. And it's not a redemption story. Straight out of the offenses, she was shortly thereafter hired. The school system is not allowed to hire people with certain offenses that you note here, but for other offenses, they can and do hire people, including with some things that we might consider disqualifying. And she was teaching first graders and leaving the classroom to deal drugs. And just, it made me think of this, because sometimes if we're not explicit about what is or is not acceptable behavior among our state employees, those who can be dangerous to children take advantage of that. So anyway, thank you.
So, and look, this is a very, very serious subject. It's a very, very serious bill. I understand it's very, very complex. Now that the hearing is over, from a side note, I know that one of the questions was going to be coming, was there 75 times that William Shakespeare addressed? I know you were. But the answer is William Shakespeare did not directly address the modern concept of juvenile protections of minors.
Yes, in fact, he had two minors who were engaged in some juvenile behavior.
That's right. So
that resulted in their deaths.
It was a little silent there.
Yes.
Thank you.
Thank you so much. That concludes the hearing for Senate Bill 454, and that concludes our hearings for today. Have a great weekend, everyone.